SI for 1 year.
Legend.
Meet please, Lordship.
Yes.
Lordship, I beg to mention item number 8 of today's list, Lordship. It is a matrimonial appeal, Lordship.
Yes.
In this case, I will Metro sent for mediation. Mediation has failed, Lordship. I would like to file one additional affidavit, Lordship, to bring on record some documents, Lordship, for proper resolution. And my learned friend is also have some difficulty today, Lordship. So
What is the difficulty?
for orders after
No, are you challenging the permanent alimony or challenging the divorce?
divorce as well as permanent alimony, Lordship.
You've been living separate from 1998.
Yes, Lordship.
Then 25 years have passed.
Yes, Lordship. Yes. Admittedly, but Lordship, the alimony in the mediation, he doesn't want to pay, only wants to pay 1 lakh rupees. My, and Lordship, some documents are there, Lordship,
Alimony, how much was granted?
5 lakhs. 5 lakhs, Lordship. And he's a government employee, Lordship.
Government employee?
Yes,
How
Lordship.
much?
His drawing salary more than 30,000, Lordship.
More than 30,000. What is the fourth grade?
Grade 3, I suppose.
Grade 3 will be much more.
No, he's in his grade 4. Well, he's in police personnel, Lordship.
Constable.
Constable.
You see, one thing is, with regard to permanent alimony, was any affidavit submitted by either of you before the trial court with regard to your assets and liabilities?
No, no, Lordship.
And we submit.
And Lordship, I was deprived of doing the cross-examination, Lordship. For COVID period, the matter could not be, the parties could not appear for the learned
So what affidavit do you want? What affidavit? This is
Lordship,
appeal. What do you
Lordship, during pendency of the divorce case at Nolway, Lordship, the respondent here has married a second wife, Lordship, and her name has been incorporated in the service book also, Lordship. Which amounts to-
After the decree,
No, Lord.
before the decree.
We don't have any instruction, Your Lordship, regarding that. We are also coming to know from him only, Your Lordship. I have got one document, Lordship, actually. So I,
That is a different issue now.
yes, Lordship.
That you can,
Even Lordship, after the Lordship.
other than why? Okay. Right. Mr.
SN Krishna Trail.
S.N. Krishna Tralaya. Learned counsel for the appellant, prays for adjournment of the matter. On the ground that, for what?
For filing,
Just like that.
no, for filing an additional affidavit.
What additional affidavit? This is an appeal.
Yes, Lordship.
What additional affidavit? There cannot be an affidavit. You've got to, the appeal has to be decided on the basis of what is there in the report.
Lordship, then for personal difficulty, Lordship.
Please for adjournment on the ground of personal difficulty. Mr.
S. Paul, Your Lordship.
S. Paul appearing for the respondent husband
Yes, Your Lordship.
submits that he has got no objection to the same. The matter pertains to a decree of divorce being granted by the learned family court. Who filed the suit? Husband.
Husband, Your Lordship.
On the basis of the suit filed by the husband. The case of the parties was that they had married in 1993 and had started living separately from 1998. While the impugned judgment passed by the learned family court, the a decree of dissolution, a decree of divorce has been granted by the Leonard family court with permanent alimony amounting to
5 lakhs.
rupees 5 lakhs to be paid by the respondent husband. The appellant wife is challenging the same. Is challenging the divorce decree.
Divorce as well as divorce was a divorce.
Is challenging the, so what, you want either hire or divorce? What? What do you want?
Actually, Lordship,
What do you want? Make up your mind.
Lordship,
You want more money and divorce, or you want no divorce,
Lordship, more money and divorce.
more money and divorce?
Because the daughter is to be,
So basically you want money, that's all. You don't want divorce. You don't mind the divorce.
because after 25 years, Lordship,
Correct. That is what.
no possibility.
No
The
possibility.
only the difficulty is the daughter is having some difficulty because she wants her father, Lordship. But
That
that
is
cannot
a
be the
different issue.
Yes.
That is a different
Yeah,
consideration.
yes,
That-
that
We-
cannot be.
That's a different. Okay, right. What have I said? The divorce decree. So stop. The appellant's counsel submits that the appellant would not press his claim for a divorce decree if the permanent alimony is increased. Is it? Do you want me to write that? No.
That may not be.
Okay, cut
recorded,
that, cut that.
That may not be recorded.
On the prayer, the parties list the matter on
After puja vacation.
when?
It may-
We cannot keep
in
everything
the-
hanging
in
in front,
the
huh?
Second week of November.
List the matter on 2011. Not 2111. You make up your mind.
Yes,
There's
Lordship.
nothing, you basically you want money. That's
Yes,
all.
Lordship. That is true, Lordship.
Ah,
That is true.
But basically you want money. Acha. But one thing, both of you have stated that you have not submitted your affidavits of assets and liabilities,
Yes, Lordship.
correct?
Because Lordship, I have debarred from submitting my evidence, Lordship.
No, now you submit. Right. In the meantime, the party shall submit their assets and liabilities in the form of an affidavit as required and as held by the Supreme Court in the case of Rajneesh versus Neha, reported in 2000. Again, I'll have to do. Reported in to submit that the appellant has been convicted under section 6 of the
Six of
POCSO
the
Act,
POCSO.
read with section 342
Yes, Lord.
IPC,
Yes, yes, Lord.
by judgment dated 31/3/2023 passed by the court of the special judge bracket POCSO bracket close Pokraja in case number special
Special case.
3/2021. Ms. S. Jahan, additional PP accepts notice on behalf of the state. Applicant shall serve a scanned copy of the appeal and the IA to the registry of this court, who shall thereafter forward the same to the additional PP. So the additional PP shall furnish the same to the OC of which police station?
Don't have a copy.
OC of the
Gosaigaon Police Station, Lord.
Gosaigaon Police Station. As the case pertains to Gosaigaon PS case number
Lordship. PS case number 425
425
dated 27/9/2019.
dated 27/9/2019, comma, who shall serve the same upon the respondent number 2. Is it?
Lordship.
Who is the respondent number 2?
Lordship, respondent number 2 is the mother, Lordship.
Bracket mother. But then there's
Lordship,
no
the
father,
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 sorry, your lordship, father. PW
like
one
the father of the victim, huh?
Sohar Ali.
A report of service should thereafter be made by the OC concerned. This is a matter after 4 weeks.
Lordship, I, lordship.
I,
Yes,
right,
secretary.
Ms. S. Jahan is granted 4 weeks time to submit her, WO in the application under section, WO, that's all. This is a matter after 4 weeks.
Obliged.
I feel your lordship, but I am appearing as a legal aid counsel member, just secretary. of the-
Okay, right. Third, Miss M. Das. Learned Legal Aid Council. Who submits that the judgment dated dated 14/6/2023 passed by the court of the Sessions Judge, Dema Hassau, Haflong, in Sessions Case number 63/2018, by which the appellant has been convicted under section 363/376/4 POCSO Act. 363, 376 IPC, and read with section 4 of the POCSO Act should be set aside. Not read with, they say and. Should be set aside. Ms. Admit the appeal, call for the LCR. Ms. S. Jahan accepts notice on behalf of the state. Then the same thing, that no, after you write, no, it'll be different out there because legally, no. So
That was also legal aid. Oh,
that was not legal aid.
the earlier one was also legal aid.
Lordship, that-
Oh, legal aid.
Yes.
Uh-huh.
Then who's going to?
Oh, yes, registry will do it.
Today,
Registry will
Registry
give
will
it
have
to
to
us.
do it. But what did we say in the last order? After call for the LCR, we have said what the counsel for the applicant shall. The counsel for the appellant shall. What? Read. What was said? Before applicant, you cut that. Appellant shall take step. What? Just read appellant shall take. No, item 2, please read item 2. No, before that.
Before that.
That's
Yes,
what.
that's-
Just read appellant shall serve. No, cut that first sentence. Appellant shall serve. Cut that. Cut that sentence. Then you write, the registry shall give a scanned copy of the appeal and the IA to the learned additional PP who shall have, then it continue, okay? Then here also same order,
Same.
but out here it'll be which, what PS?
My lord,
How long? it?
Dima Assam.
Out here it'll be the OC of the, which OC? OC of the Haflong PS. Haflong Police Station, and will be Haflong PS number 81/2018. Okay. Then in the IA, you write same order
That-
as item 2.
4 weeks.
4 weeks. That-
Obliged.
Secretary appeal lordship.
5 is already admitted, I believe, and
But in the last order was 24/7/2023, it was not mentioned as admitted.
oh, acha. But then I
Last
filed
order
my
is-
objection there.
24/7/2023. Item number.
Okay, this item 4, criminal appeal, you write admit the appeal, call for the LCR. Huh? This is the matter after 4 weeks. Then in the IA, you have filed your written objection?
No, this has come up for the first time. Lalchan, I have filed my objection.
Okay.
5, I have filed.
And
my-
item, in that IA 614, you write Miss L. Jahan is granted 4 weeks time to file written objection. This is the matter of the 4 weeks. Then in the other, one,
Confidential.
and in the
LCR is already
2
called.
254 is,
LCR is here. LCR is called and I think,
oh, LCR is here.
no. But I'm told in Lalchan, LCR had come. I don't know. But it's not
LCR,
reflected.
there's no
Not
LCR.
reflected also.
Just show me 254. Criminal appeal 254. Acha, LCR already called in the.
We already
That is why we
Yes.
did not call here.
And I heard from Mr. Chaudhary that it has already come to our High Court, but perhaps it's not tagged or
Just,
it's not reflected.
just. leave it in there.
Oh, Lalchan and my High Court.
No, LCR not received.
Acha.
Okay, then in this 254, you just write, send a reminder for the LCR. Then in the IA, have you filed? No,
No, Lalchan I filed.
Lalchan, they have filed.
Yes.
Uh,
Lalchan I filed.
Miss Elja, in this IA 606. You write, Miss El Jahan has submitted her. Is it there? Show me. Give us all the files. not the
606.
IA.
606.
606. The IA is there.
Perhaps it will be in the record. I filed it.
And give us all the files.
I filed it. I have not checked whether it is in the records.
Okay.
That's-
In this 606, you said, you right? WO has been filed. List the matter after 4 weeks.
Alright. Yes, this is statutory appeal filed within time.
Are you a legal
No,
aid counsel?
no,
you are-
Sir,
This is a private appeal.
Okay, right. Mr. U Chowdhury, learned counsel. Appears for the FNL. This appeal has been filed against the judgment dated 11/8/2023. Passed by the Special Judge Jorhat in special case number 10/2019. Comma, by which the appellant has been convicted under section 376(3) IPC. Read with section 4(2) POCSO Act. However, the appellant has been sentenced under section 4(2) POCSO Act. Admit the appeal, call for the LCR. Mrs. Jahan appears for the state. The appellant shall serve a scanned copy of the appeal and only of the appeal.
Only-
Of
only
the
of
appeal,
the appeal.
the appeal to the registry of this court, who shall furnish the same to the
additional.
learned APP. The learned APP shall forward the same to the OC of the,
TO police station,
how do you spell TO?
TEOK,
TEO.
TO police
TO
station,
police station.
and the case
Case
pertains
nu-
to.
Case
TO
number is
case
108
number 108
2019.
of 2009. Who shall, who shall serve the same to the respondent number 2?
Yes.
Who is he? Respondent number 2?
Lordship. Yeah, she is the mother lordship. Mother lordship.
Why he's got no father?
Mamu ko le ja.
There was father lordship.
Huh?
She is also having a father also, but mother has lost the FIR lordship.
Now the problem is,
No, that will come only when the person is not found.
Okay.
Otherwise, if the informant is female, herself is female, there will be no difficulty.
Lordship, because husband is still.
Only when,
No, but then when you read the judgment.
Huh.
Order of the division
Acha.
bench. It says that it should be to the victim
the
or to the
guardian,
guardian.
mother,
Now, but there's another order passed by the other division bench.
Hmm.
Which says that section 64
no,
provides that it
uh-huh.
should be the male.
No, that is what I'm saying. 64 will come when the informant is not found. And in his place, a male member has to be in.
What am I saying? Number two, a report should thereafter be made with regard to the service by the OC concerned. This is a matter after 4 weeks.
Public. It's a matrimonial appeal.
Huh?
There is a delay.
How much delay?
165 days.
165 days,
Yes,
is it?
yes.
Have you seen the order passed by this court on
Yes.
7/8/2023?
Yes, madam. Yes, but the necessities that could not be taken in relevant point of time, there is a matrimonial case.
We have filed Wakalatnama yesterday.
And the full stop, huh? This appeal has been filed.
I is there only for that. I think we'll move the bail application.
Okay, for that, okay, for some,
My objection is there.
okay, sometime. Okay.
15, this is a state appeal against acquittal. On the last occasion, I was supposed to take notice on respondent number 2, the other lady. I have sent it. I have sent it by mail. The office note also shows that,
Is it
But it
required,
is-
required, this is against acquittal.
this is against acquittal. But then the counsel appearing for 1, he was earlier appearing for 2 as well. But later on, he said that I have no instruction. So Lordship had issued notice to respond number 2. So now respond number 2 I've taken through the OC because last time it went, it was not served. This is not normal.
Who is respondent number 2?
She is the she is the cook and the cleaner of the NGO. And the respond number 1 is the superintendent. Allegations are against her also. 323, she used to beat up the childrens.
Now, what is to be done?
Let us await. I'll bring the report. I've sent it through Sibsagar OC.
When, wait till when?
I have sent it long back on 8, 9. I've sent it actually. That I'll on Monday, Lordship will take it up. I'll get a report Monday or Tuesday.
Okay, right. Ms. Jahan. That the matter may be listed on Monday
Hmm.
to enable her to get a report from the OC of the
Sibsagar
Shiv Sagar PA
district.
regarding service of notice to the respondent number 2.
2.
This is the matter on Monday.
May I please, your lordship? Can you kindly pass over this matter for time being?
To me, sir.
Lordship.
Yes,
This matter have entered it means for the respondent number 2.
oh, very good.
Last time I was supposed to serve notice, so she is appearing.
Lordship.
So what do you want now?
Can you pass over the matter for time being?
Why?
Senior is on the way, lordship.
Who is on the way?
My senior is on the way.
Nothing has to be done.
What will be done? What will he come and say?
Let the paper book be prepared.
Yeah.
LCR is here.
Okay, right. Yeah, you have not submitted anything, Bakaladama.
Lordship, we have filed the Wakalatnama.
Wait, today.
Lordship, 2 days back on Lordship.
Okay, Miss
Lordship, and Ms. P. Barua.
P. Barwa. Submit that she'll be appearing for the respondent number 2. And she has submitted her Bakaladama 2 days back. Full stop.
Yes, in it.
As LCR has arrived. Registry to prepare the paper book. And this is the matter, no, first stop, this is the matter after 4 weeks.
There was an it was rejected earlier, so. only
Lordship,
appeal license.
demo of the appeal may be provided, Lordship.
You'll be getting the paper.
DP of it. Item 17.
We'll go for it.
As per office note dated 19/9/2023, the service report awarded about.
No, he is appearing,
Okay, very good.
but he is legal aid counsel. Actually.
Oh, you're appearing. Legal aid counsel?
Respondent number 2.
Point number 2 has engaged you.
Legal aid authority. is the
Legal aid
second.
authority has appointed you to.
Because normally we send this, if
Where
they
is, where is
cannot.
the, where is the letter from the legal aid authority?
There is a. This is the. This is the order and the copy, perhaps this is the notice.
No, there must be someone appointing you. On what basis? On what basis? Who told you to appear for the point number 2?
This was a notice upon respondent number 2, and he got it, perhaps it came through that office. I don't know,
Huh?
I don't know how they appoint. Maybe there will be some paperwork, but what's the matter? Not required, actually, we write in the letter if they
No, no,
cannot
it's
respond.
okay. We have got no problem with him being the counsel, but the only problem is that there has to be some letter or something to show that the legal service authority has appointed him as the legal aid counsel. Not tomorrow somebody comes and says, no, I am the one. Now, how do we know who is the correct authority? Who is the correct counsel?
We will collect one paper on the next.
Can you correct any paper? Okay. Right. Mr. What is your name? Jadas. Submits that he has been appointed, he has been appointed by the State Legal Service Authority. District Legal Service. What High Court? What High Court Legal Service Authority? Committee. What High Court Legal Service Committee to appear on behalf of the respondent number 2. So he submits that he will produce an authorization letter by the next day. The authorization letter by the next day. Next para. As LCR has not arrived. Registry to send a reminder for the same. This is the matter after the beginning.
Not. Oh. There's a delay.
Yes, yes. There's a delay of 6 days, Lordship.
Okay.
And this IA is for combination of delay.
Heard Mr. Bhattacharya, learned counsel for the Bhattacharya, learned counsel for the applicant who submits that there is a delay of 5 days,
6 days, Lordship.
6 days in filing the appeal
Lordship.
against the judgment and order dated 1/8/2023 passed by the learned special judge, Pokso, Pokraja in special case number 20/2022. By which the appellant has been convicted under section 4 of the Pokso.
6, Lordship.
Section,
Just a moment. Rigorous imprisonment, Lordship. Under
I am
section
not
6.
on that. Under which section?
Under section 6, Lordship.
Then why have you written 4?
I beg your pardon.
Judgment says 6.
Under section 4, however, as per the time, going to punish him, okay. 666.
6.
I am highly sorry, Lord.
Okay, it's 4 of the Pokso, 6 of the Pokso.
Okay, ma'am. Oh, yes.
Ms. S. Jahan, additional PP submits that she has got no objection to the delay being conducted. On considering the grounds for the delay and keeping in view the submission made by the learned additional people, the delay of 6 days is condoned. Registry to register the appeal and the IA. And the application under section 389 CRPC and list accordingly. I accordingly dispose of.
Lordship, this matter has come up the DNA method.
I know, where is the council? I was seeing them.
He's on lag in foot number 20.
We'll wait for some time. Public. Yes, what to do?
Amir Hamza, yes, sir. I was supposed to serve the notice upon respondent. It is served. I've sent the mail. Lordship can see it was earlier served on a female member. Then it was changed. Now it is served on Amir Hamza. Oh, no, this Majam Ali. Lordship can see the report.
Yes.
And I think,
print up.
yes, a notice, yes, it is served. It's served upon Majam. But I was supposed to file my objection. Because he has corrected the IA, he had refiled it. So objection I have not filed. Earlier objection can be taken, but it will not.
We can hear, there's not a problem.
Not sure. This is Paisa. Oh.
Basic practice.
Just a minute, just a minute.
Yes.
Just wait.
As far as notice, Lordship will see this is served. Salva,
Who is this? The father?
no, the Jaharuddin is the father, but the LTI of Majam Ali, above that.
No, so who is this? Who has
This is-
received the notice?
The informant,
Informant herself?
himself.
No, informant, who is the informant?
Who,
Is he,
informant,
Is he
yes,
the
sir.
relative or what is he?
no, father, he has to be.
Mazum Ali.
Majam Ali is the father. Yes, father
Father?
of the victim,
Okay, right.
14-year-old.
Mr. J. Ahmed appears for the appellant. Ms. S. Jahan appears for the state. No one appears for the respondent number 2. Even though notice has been served upon the father of the victim as seen from the scanned copy of the service report issued by whom? Who is he?
He is the
OC.
OC, Salbari
Issued
Police
by
Station.
the OC of Salbari
Salbari
PS.
Police Station.
Has the records come?
Records are.
A paper book under preparation, right? Office note dated 13/9/23 states that paper book is under preparation. So this is the matter after 4 weeks, huh? In the mail. Now give us the appeal.
It was after vacation.
Huh?
I am maybe reached after vacation in anything. That may be it.
You're out, okay. You wanted after vacation.
And
Why?
there is-
No, today I am resident.
Huh?
Today I am also ready.
You're ready? Okay.
So I am.
I think there is an order that I'll file my objection, I think,
No,
In the new
objection
appeal.
already filed, that can be taken into consideration.
already filed, but I think in the IA also perhaps.
You've already filed what?
Earlier, I filed.
Earlier IA for what?
Same, same.
Well,
Acha,
Same.
389 twice.
389.
yes,
There was some mistake and
mistake
so.
or
we
typical
correct-
mistakes and that is I would do it
Okay.
and tell.
Let us see what is the case.
My lord, in this case, only fact is this, my lord, the medical report did not support the position case. Number one. Number two, the informant stated that one Hafizul Abdul Haq, he was the son of the informant.
No, first of all, why do you say that medical report does not support the prosecution?
Because there is nothing, my lord. If you also calculate medical evidence, nothing, my lord.
What is the number there? Where is the
11, PW 11.
Give us the idea. I think that. Then IF 510. Yeah. Let us see here. Where is the written object? Here it is. Yes,
Medical evidence, my lord, Dr. will
page.
It is not annexed. Evidence but not annexed, ma'am.
Not an X.
But in judgment, but judgment it has been mentioned.
Okay, let us see. Judgment. In the appeal. What?
Page, we start from page 24. Page 23 is there, my lord. Paragraph 6, 16, page
Page
23.
24.
23, paragraph 16.
Page 23 of the judgment.
Appeal,
Appeal.
appeal.
You are changing your statement as we are moving along, huh? Yes,
Then, my lord,
what does it say?
here is a melody, as far as the history is concerned, down below of the paragraph 6, history taken from the individual in presence of female avenger on the death of Sancho, incidents occurred with her. As per Ellie's victim girl on embalmment at about embalmment, one unknown guy got hold of her and took in a jungle and had forced sexual intercourse with her. While she went to collect some vegetables from their field, she, along with her father, came back home and reported to the police, and she was brought to Ephraim Department for medical examination.
Okay, page 25.
Now, my lord, page 25. Opinion, my lord. On the basis of physical sensor, number one, no evidence of sexual penetration detected on her person. No evidence of injury detected on her body and private part. On the basis of dental and physical examination, she was above 14 years and below 17 years of age. During cross examination, the PW 111 stated that the victim did not mention the name of the accused at the time of narrating the history. Her history before her, and that she did not find any injury on the body of and person. This is the on fact, my lord. Now, the victim, PW1 informant, he stated in his evidence that one, Abdul Haq said to be his son, he is Sodavkar,
PW1.
PW1.
Yes,
Yes, has seen the occurrence. The first part I am reading. First
yes.
part. The house of the accused is situated at.
Where, which page?
Lordship will get it in the LCR. He is reading the cross
No,
examination.
no,
Ah,
yes, yes, my lord.
only you know what's going on.
Yes, paragraph.
All of us are,
Yes.
like a blind man.
Yes,
We're groping in the dark. You're the only one with the torchlight. Unless you give us
Yes.
torchlight also, then we cannot go up the same garden path.
Page
Will be
17,
lost.
page 17.
Huh?
Page 17 of the
Page 17, yes.
paragraph 8.
Paragraph 8, yes.
Schedule 1, a father of the victim, stated in his examination sheet that about 3 years back, one day at about 3 p.m., when he was working in his paddy field, and his daughter victim went to the bitter garden to bring bitter down, and when she did not return home, his son Abdul Haq went searching for her in the same garden, but did not find her. After crossing 2 bighas of land, therefore, he saw accused Amir Hamza committing rape on the victim in a jungle, and immediately Abdul Haq reported about the incidents to him. And he immediately went to the place of occurrence and saw the accused going away. And after he brought back the victim to their home, she told him that the accused committed rape on her body by gagging her mouth, and thereafter he lodged an azhar against the accused in Anandabazar police court. Presumably, one further stated that at the time of occurrence, 14 years of age. Now, during cross-examination, my lord, presumably one stated that the house of the accused was situated at a distance of 3 kilometers from his house, and that the accused was a tractor driver. Presumably, one further stated that he lost the azhar after 2 days from the occurrence of the occurrence, and that Anandabazar police outpost was a distance of 2 kilometers from his house. Presumably, one also stated that he did not stated in his azhar that when the victim did not return home, his son Abdul Haq went searching for her in a shade garden, but did not find her there. And after crossing 2 acres of land, therefore, he saw accused Amir Hamza committing rape on the victim in a jungle. And immediately Abdul Haq reported about the incidents to him. And that after he brought back the victim to their home, she told him that the accused committed rape on her by gagging her mouth. Presumably, one also stated that he tried to settle the matter in a village meeting. Now, my lord, here that was not stated that some suggestion has been given that there is a dispute regarding money. He is a tractor driver. Her father used her tractor to plow the lands. He plowed the lands. He did not.
Her father used the tractor
Tractor of
to-
the
of this accused.
and a rent basis, but he did not pay the balance amount. When he repeated asked him to give the money, that not given. And suggestion has been given to them because of you are not paying the money due to the accused. That is why you file this false affair by making false allegations. Now, my lord, PW2, the victim, she stated that not Abdul Haq, she stated one Habizul Haq. One Habizul Haq saw the evidence. Okay.
So Abdul Haq saw the occurrence.
Yes. Other
And
informants
and this person, who is this PW1?
father. Informant.
Father is, what is his name?
No, father is the Mazum Ali.
Mazum
Mazum Ali.
Ali, out here, Mazum Ali said that he saw the rape.
His son.
His son saw.
Abdul Haq saw the rape.
Just a minute. Son's name is
Abdul Haq,
Abdul Haq.
but he has not examined
Okay, Abdul Haq saw the rape.
rape. But
And Abdul Haq's father's name is
Mazum Ali.
Father is Mazum Ali.
Mazum Ali.
How do you spell Mazum?
M-A-J-A-M, Mazum Ali.
M-A-Z-A.
J.
J-A-M. Mazum Ali. So Mazum Ali is a tractor driver.
No, he is the father of the victim.
Father of the victim.
Informant.
Father of victim. And the father
And the
of
father of Abdul Haq.
Abdul Haq, yes. So this Mazum Ali, he owes money to this accused.
Yes.
Because the accused has a tractor.
Yes. And
And
he
not-
has the landed property, he plowed it and used his tractor, but he
Not
did not pay the amount. This is suggestion has been given into every schedule 1, 2 also.
Okay.
Now,
And now PW
P2
says-
is the victim.
victim says,
Victim says that one Habizul Haq has saw the evidence. Okay.
PW2,
P2.
Habizul Haq. Okay.
Yes. Paragraph 9 of the judgment.
And when the father read the he saw the accused committing a opening her clothes.
And that fact has not been disclosed before the father.
Now Habizul Haq was examined or not?
No,
And was this Abdul Haq
he is
examined?
also not examined. not examined.
Because what I feel, of course, we'll have to go deeper into the records, whether Abdul Haq and Hafizul Haq are one and the same person.
Whether they are, assuming that they are,
They are.
they have not been examined.
They have not been examined, but the victim said it was her brother who came and saw. And the father also said, my son went and saw. Only the difference is in the name. And he must
But
be a
then,
small boy.
you see, the incident occurred when?
In the daytime, 2-3
What
p.m.
date?
Date is 9/9/2000, 7/9/2013, 19,
7/9/2019,
19 at 3 p.m.
3 p.m. Now, when was the medical examination done?
Medical examination, of course, is in his favor, but that will not be clinching again.
No, whatever.
ये क्या बोलते हैं medical examination?
Yes, when was the medical examination done?
Uh,
The problem is
9/9/19.
9/9, 2 days.
9/9/2019. Why? When was the FIR filed?
9/9.
After 2 days.
No, FIR was also filed 9/9.
And now they say that they want to settle the matter amicably. How, my lord? A rape case, settle the matter amicably.
And
That is why
Where do they say that they want to settle the matter amicably?
he stated
it was before the FIR.
before the affair.
And
Before
they
the
wanted
FIR.
Yes.
so that is how 2 days delay occurred. And one more aspect, father had seen him running away.
No, he saw the accused committing rape on her by opening her clothes. Opening her clothes is not rape. Maybe attempt to rape, but it's not rape.
Both should be taken together. If he is appearing in one of it, madam. Madam, I'm praying for a short time, madam. 10 days time for filing a complaint. He was directed to file the bail objection earlier, my lord, by earlier last quarter. That is one such. Bail objection is ready. We are waiting for approval, madam. 10 days time. So why 10 days, madam? That is, if it is all ready only for approval, madam, because the plan is behind the.
I don't know, I don't know, but when can you file?
Madam, I have been asked for 10 days time, madam. Within this 10 days time, we will be filing it.
10 days time, the puja will start within another 7 days.
Yes, quite okay. Let the matter come up after. Let him file first, my lord. Again, after vacation, he will say something.
You file it by next week. So that at least he can go through it during the puja.
We'll inform him, Mara, the moment we file it, Mara. Let his own submission is that it's ready only for vetting. It is being. No,
It's been set for vetting.
Mara, we are waiting for the
Approval.
approval, Mara. We do not know how long it may take time. I've been asked say that 10 days time will be sufficient. You're looking at just so that just to avoid another prayer for.
We thought we will dispose of this matter. Yes.
Lordship, I think the state of Assam has no role to play, I think.
Yes.
But in the office that I have seen, has not filed that objection. But we did not file, so formal party.
Actually, why we made the party minor, though is not required minor, because the informant in this case was a Assam police personnel minor. So for all safety, we have made a party, not a formal party, but since court has directed to furnish the copy, we have furnished.
You file it by Thursday at least.
Well, but I don't know, I've been, there is an office, Mara, they have asked me, stick for 10 days time and meantime we will be filing it. I cannot say.
But then you are the. The court work and the process in the work should be in your hand, not in their hand. You're supposed to advise them.
Regarding, yeah, quite true, Mara. But the thing is that those, this thing coming from Delhi, Mara, that is, it comes from Delhi.
Okay, anyway, the court should be open.
Mara,
The office will be open.
Office will be open, that is it, Mara. We'll find it.
Okay.
That is it. It is not
Mr.
that, Mara, that we have to wait for November to file it, Mara.
Okay,
That is
Mr.
time within.
Mr. DK Das, Leonard Senior Counsel for the NI. Prays for 10 days time to file the written objection. Praise allowed. This is the matter after 10.
Well, as regards this matter has been now tagged with the earlier item 26, matter, today's list, matter. So it may also be similar order.
Okay, in that other order?
Yeah.
In the other order, have you filed?
Yes, Lord.
Yes, they have filed it, my lord, because we have tagged it yesterday, my lord. They are appearing it.
Okay, the other matter also.
26,
Huh?
Item number.
item 26 of
So release the matter after 10 days. Along with
along with this. matter.
criminal appeal 340 is like 2022.
That will do, my lord. Much obliged.
Lordship, we have filed our affidavit in this matter. On record.
Where is the other side?
Not there. After vacation.
Huh?
After the vacation,
No, we could have at least, the IA we could have disposed of because it's your written objection is already there.
yes.
Right, no one appears for the applicant. Even though written objection has been filed by the learned APP. In the interest of justice, let this matter after the vacation. Then, have you got the paper book?
Yeah,
The extra. That's in the appeal copy, that is our copy, don't give our copy.
paper को घुस से नहीं गई. ये भी रखा है.
No, but we have to see, just give me the file. We have to see, they might have already given to the
Maybe.
APP's office,
Most likely. ma'am.
most likely, don't just give like that.
M. Sharma.
Paper book
Sharma?
furnished upon Miss B. Buyan,
Upon my lord.
additional fee upon
Yes.
you,
But received by my lord, M. Sharma,
M. Sharma.
of our official employer.
Okay, in the main appeal, you write. Office note indicates that paper book has been furnished upon Miss B. Buyan, additional fee.
And received by lordship. Anything.
However, as no one appears for the appellant. This is the matter after, what I think, after vacation. After that.
Lordship, can one line be added and received by. Received
Okay,
by.
and received by
Mr.
Mr.
M.
S.
Sharma. M. Sharma.
M. Sharma. Not and, it's a received by M. Sharma.
No, we have not, that's the official. That is our lordship, our concern, but it's the official. Most of the, my lord.
Received by M.
M.
Sharma on behalf of. Where about that other item, that other item, the DNA matter?
Mr. Azad is busy.
We will take it up at 2 and tell him
Two.
that Azad. We'll take it up at 2, that DNA matter.
Lordship.
Even if he doesn't come, we're going to pass an order. Please tell him that.
In fact, this is that NDPS matter which I had taken time day before yesterday to reply. I'll not take much of your lordship's time and finish up early. Now here.
Yeah.
Now here, what I understand, of course, subject to correction, what my learned friend says. I mean, what are the arguments that he has made? I'll just curl it out. First is that he said that the Caesar list, although was exhibited, but the Caesar witnesses, 2 of them were not examined, and 1 had in fact not supported the Caesar.
Hmm.
And the second point that he says that, of course, that is consequent to the first point, that possession, it was not from his possession, so it is not proved. that conscious possession is not proved. And then he said that even his statement leading to discovery was not voluntary. These are the main grounds on which he has challenged us, and he had said that it amounts to it will result in acquittal. Now, the first point that he has raised that this discovery said the seizure is not proved. The seizure of the contrabands were not proved. In that respect, I would like to say, of course, those two witnesses were not found. It is mentioned in the charge sheet itself that those were not found and not were examined. And the third witness, who is a
yes.
constable. Oh, yes.
Just a minute, huh? I think you'll take some time. Just let me finish this.
There is another appeal also.
Yes, Mr. Ahmed. We have rejected your IA, that bill, that you know that. Now, we are tentatively of the view that we are going to direct DNA to be undertaken in the presence of the trial court. And that we are of the view that we will send it back.
But before that, just one thing may I point out, Lordship, before directing the DNA, let her obtain the instruction whether prosecutor is consenting or not, because she cannot be compared. Even if I will be compared, but she cannot be compared. So let her obtain the instruction and therefore Lordship may direct it.
No,
because it's
no.
Because she may not consent and she
No.
cannot be compared, it is in
No,
very
that
rare
is
case
loss
also.
of
No, no,
conviction.
Where does it say that? Where does it say that?
Because that privacy. that-
No. The privacy thing is only with regard to paternity involving married couples. Where the infidelity of in fact, the thing is that those cases are where the child would be the major sufferer. And because of section 112 of the Evidence Act, because of that. Now, subsequent to those judgments, there have been cases wherein the infidelity of the wife was questioned by the husband. And there also, the only way to test the infidelity is by testing the child. And the Supreme Court allowed. And in that aspect, it's indirectly, in fact, maybe allowing which it had not allowed earlier. So we'll pass that. You want to clarify this? There are always involved. It'll be good for everyone, in fact,
Yes,
if
good for
it can make that. So we are sending it back. Maybe 2 months time we'll give to them to have the test done. And after that, it should be sent to us again. And depending upon that, the entire issue will be cleared.
All right.
So your name is Mr. basically A. Amit, no?
Yeah. My senior can be recorded. He is on like. he is supposed
So we will record him.
to- his name.
Okay, as of today, he's appeared.
Yes.
Basically, the issue has already been argued by both of you on the last day. So the IA was disposed of. Now in the main appeal, we will pass this on.
I am assisting him.
Yes.
All right.
And there is one more order matter, Rafiqul, where Mr. Ahmed is appearing.
Is it? For which order? Item 14, just a second.
It's for bail. If your lordship takes up this matter, I am here. I will be
Oh, it's a, for what base?
for consideration of bail.
Okay. This will, I don't know how long they'll take.
It will take.
No,
I'm here. I will be.
not
there.
very long, not very.
Not very long.
Actually, one point has to be addressed here. I think it's missed out. That IO told that the authorization letter has not been exhibited, it is missing. So one point is very important that
IO IO states that
IO in his, during his cross-examination lordship, he stated. I'll just take just 1 minute time regarding this. IO was lordship PW12. And he in his cross-examination, he said that SI Montu Decker take up the investigation and recovered the substance in connection with so. Data so is not found either in the case diary or in the document attached to the charge sheet.
what letter?
Authorization letter to
Author-
seize and investigate. because it was
Authorization letter dated
that was
Same day. of
1/4/15 lordship,
1/4/15. That was not what?
found in the record, neither in the CD. That means this is without authorization of 41 subclause 2, because he is an SI.
Violation of section,
41 subclause 2 lordship, NDPS Act. And another thing,
but
lordship,
that can be rectified, that may be cured.
can be,
That's a curable defect. If it's already, if it is already
not
there,
been-
always there.
it has not been rectified so far as the record says, lordship. And there is one more thing, lordship, I have not found in the record, lordship may kindly have a look. Because that will cast a doubt regarding the scissor. Annexure 1 is not there. The inventory to be prepared, while scissor of the NDPS Act.
52A mean,
Lordship. That is not in the,
annexure 1 is not there.
if I may kindly. Yes,
What are you talking about? 52A2, 52A2,
yes, yes.
52A2 not complied with. That's
Not
what you're
complied.
saying. Not
Because
complied. with.
There has to be an inventory that we have not found in the paper book. I think it's not there in the case record also.
So you are saying that, okay,
That casts a doubt regarding the scissor, because scissor they have not established, and that is also not there. The inventory part.
so whether the non-making of inventory under 52A2 would reshape the
No.
entire trial.
No, I am not on that lordship. What I'm trying to satisfy your lordship, had there been a scissor, this document ought to have been there. Because
so-
there
so-
was no
so-
scissor,
Ah.
scissor itself appears to be doubtful. Therefore, these documents are not there. That is my submission. Otherwise,
No, but what is the effect or the consequence of that document not being there?
I am trying to fortify my argument that the scissor itself was not done. There is in fact no scissor. The scissor has been created.
No, okay, that is, you are trying to fortify your argument, that's okay. But the simple question asked by this court is, in the absence of such a document, what would it imply?
Now I would give two answers to that lordship. Supposing scissor would have been proved and annexure 1 was not there. No pattern. Scissor has not been proved. Vis-a-vis annexure 1 is also not there. So it casts it out. It fortifies the doubt. I am on that ground now.
Otherwise, that old judgment 52A is a directory, not mandatory.
Sure.
That of course is there.
I'm not on that. It is directed.
But it has to be followed. This is what it is said, but then this will not vitiate the entire proceeding.
That's what I want, that's the answer I wanted to know, what is the implication?
Lordship, that is what I am submitting before lordship.
Yes, I understand what they're submitting. You are saying that, okay, it's directory, but coupled with the fact that they were not able to prove the seizure,
Absolutely.
then the
Absence of annexure 1
so that
further casted out.
so there is an added
Added-
suspicion.
Added suspicion.
I may start with the Caesar. Now, if now, as I've just said, that three, of course, 2 points were now added. 3 points were that Caesar is not proved. It was not from his possession. And then it was not voluntary, the statement which led to the discovery. Now, as far as the Caesar is concerned, it's no doubt, it's clear from the records that 2 were not examined and 1 did not support the Caesar. Now, that will not end the matter. In fact, there are other evidence on record which has proved the Caesar. This will, these are there on records. There are other officers who have stated about the seizure. They have also stated about the exhibit. That I'll take your lordship to the other evidence which are there on the record in order to prove the seizure. First is that PW3. PW3 is the wife of Rinush. She turned hostile. But then only one statement that I take recourse to is that she said on the night of, that is at page number 13, lordship can see, on the night of 1/4/2015, Majbat police army personnel came to our house. Although she turned hostile, her hostile part will not be admitted, but I can always refer to her positive statements which supports the
Page 13.
prosecution. Yes, page 13. She said, she said, on the night, the third line from the top, on the night of 1/4, police of Majbat police station and army personnel came to our house. I have recognized both the accused persons present in the dock today. After coming to our house, police went to the rear side of our enclosed yard. This stands as it is. I mean, this I can always rely on. Police woke up us and brought us towards the road for talking to us, but then she did not go. The rest of the statements does not matter. Now here, police had gone on the night to her house, went to the backside to that extent, not more than that. Then lordship will come to PW5, the SDPO. The SDPO had clearly stated in his evidence, not demolished in the cross-examination, that he was arrested, he was apprehended, not arrested. He was apprehended and then he was, they went to his house, they apprehended, he led them to the recovery. Lordship will go to page number 18. 18 first few lines, and it is clear lordship knows that what had happened is Narcotics Bureau people from in Calcutta got the information. Then they gave the information to Guwahati office. Guwahati Narcotics Bureau people came to the police station or came to the first SP's office. SP was informed, then they went to police station and the entire incident came to light. Here SDPO had stated, on that day, a team of Narcotics Control Bureau has visited Udalguri and I have been asked by SP to accompany them.
Where are you reading?
Page number 18, first few lines.
Okay.
On the examination chief. Accordingly, I proceeded to Majbat PS Narcotics Bureau, Majbat PS. Bureau people reported us that a huge quantity of ganja is kept by Pradeep Jha. On being receiving the information, they made the GD entry as required 42. Dated 1/4 at 7:30. I, along with the then OC Majbat PS, Deepak Das, DSP, Udalguri Pranjal Bora, along with persons of Narcotic Control Bureau, proceeded to the house of Pradeep Jha. We have taken C. Pradeep Jha to the police for interrogation. If he can reply now, he can say, no, for my satisfaction, use it. Otherwise, he'll keep prompting me. And then we took Pradeep Jha to police station for interrogation. What is wrong in this? People has to be interrogated. So they took Pradeep Jha to the police station for interrogation. Pradeep Jha confessed before me and other police officers that he kept suspected ganja in his godown. Now, what he said is this confession word is wrong. But I think Lordship knows section 67 of NDPS Act. Section 67 is, in fact, Supreme Court has said that that is reliable, the confession, because they are not police officers. So section 24 will not come. But in our case, of course, that is not the case. Police interpret. Police was there. So they loosely used the word confessed. Now, Narcotics Bureau people, as well as the police went, apprehended him, asked him, interrogated him. Then he confessed before me and other police officers that he kept suspected ganja in his godown. Accordingly, he led us to his godown, situated in Nahora, in Majbat of Majbat PS. In his godown, it was found that godown is situated at a chamber like latrine chamber. We have found a huge quantity of suspected drugs in the plastic basket. In my presence, SI measured suspected ganja kept in a sealed packet. Montu Deka also kept sample as per procedure of NDPS. I was present in the said operation. So this has proved the seizure. They went SDPO is not a signatory to the Caesar list, but he had said they went on being led by the accused. They recovered those drugs and it was sealed. It was, the samples were made at the place of occurrence. Now in his cross-examination, that is not demolished. Lordship will see the middle portion of his cross-examination. They have not given me any writing. Then SP verbally asked me to conduct the operation. GD entry was made. Pranjal Bora arrived upon information and that some suspected ganja were kept by Pradip Jha.
Where are you reading?
No,
Where are you reading?
First, I mean, page number 19, after 4 lines from the top.
Yes.
And then that some suspected ganja were kept by Pradip Jha. IO has not recorded my statement. At the time of search, we have not been accompanied by local headmen, they say, but one witness said that they had taken some local people. However, at the time of search, OC Majbat had called some neighbor of the place of occurrence. Till recovery of the contraband ganja, none of the persons were arrested, but accused persons were apprehended. I, being DSP, a gazetted officer, do not feel to state that the accused whether other gazetted persons. So, the recovery at the instance of the accused is not even demolished in his cross. Cross also it stands. Now, Lordship will go to PW6. He is the SI. He had accompanied the team and he had also said that on being led. Lordship will go to page number 20, the last line of that page. The NCB team informed the OC of Majbat PS that a person Pradip Jha by the name kept huge quantity of suspected ganja in a storeroom of one Basumatari. Then the OC made GD entry.
Where are you reading? Where are you reading?
Page number 20, last line.
Ah.
I started with the last line. The NCB team informed the OC of Majbat that a person Pradip Jha by the name kept huge quantity of suspected ganja in the storeroom of one Basumatari's house. Then the OC Majbat made GD entry at 7:30. On the basis of the entry, SDPO, Deepak Das, OC Majbat, Pranjal Bora, DSP, A headquarter, 13 officials in civil dress, some police personnel of the PS, and I went to the house of Pradip Jha, situated at Majbat town. We found him at his house. As shown by Pradip Jha, we went to the house of Rinush Basumatari, by name at Nauholia. By name at Nauholia. Accused Jha showed us some bhang-like substances stored in a storeroom, resembling a toilet tank chamber of Rinush Basumatari's house. SDPO Mr. Hajorika gave me a written authority. This, of course, was missing, but the fact remains he had given a written authority to seize the bhang-like substance after weighing the same. I weighed that suspected bhang-like substances. The total weight of the substances suspected to be bhang, which was found in 24 packets containing 20 kgs each, was 660 kg. Besides these 24 packets, 6 more packets containing 30 kgs were also found. Collecting a small amount of substance from each of the packets, 30 packets with polythene was prepared. I made samples of suspected bhang, putting 20 grams in each packet, and I sent the sample packets to OFSL. They made the GD, as far as the procedure is concerned, they made the GD entry, they got the authorization at the place of occurrence, then they seized the articles, then they made the samples. And as far as recovery, it is writ large in the statement of PW6 that they had gone and on being led, they have recovered. So simply because the Caesar witnesses, something happened, it will not demolish my entire case. Then Lordship will go to PW10. He also had said it was led by the accused. I'm not going to 7 because he is not supporting the prosecution case. Lordship will go to page number 36. The sepoy of the NCB's office. Then not in so many words, but then he said, Lordship will see 2 lines, Lordship can skip. The original information was convened by our Kolkata office. Lordship got it?
Yes.
Accordingly, Mr. Samanta from Kolkata NCB office, Suresh Kumar Singh, and myself went to Udalguri police officer's office and consulted with the state police about the aforesaid operation. Then we proceeded to Majbat along with DSP and some police officials. We have found a place where ganja was kept in a tank-like chamber. Then the aforesaid ganja was recovered from the said tank and handed over to police personnel of Majbat PS. At the time of operation, Pradeep Jha was also there. During that time, I have not seen Renus Musumatari at the place of occurrence. So Pradeep Jha was there. So these evidence of 5 and 6 specifically, the SDPO and the SI, I don't see any doubt as far as the seizure of the contrabands are concerned. So as far as this first point that leading to discovery is not proved and that it is not from his possession and that the seizure list is not believable, those goes by these evidence of 5 and 6. And since it was recovered as led by him, so the possession, the conscious possession, I place a decision. The conscious possession is well proved. Otherwise, he is the person who knew. Nobody else knew it. It was behind the house in a tank, which is not visible to anybody, anyone else, except the wife or the possessor of that particular plot of land. Then Lordship will have already seen discovery statement involuntary. What my learned friend said that from PW5 statement at page 18 that I have just said interrogated. The word interrogated doesn't have any adverse consequences. He was interrogated, he was asked and he showed. And the voluntary part, what my learned friend had shown, only 313 statement. Lordship had seen just now 5, 6. Lordship can go to the other evidences also. Nowhere it is stated by the defense that he was tortured, that during the interrogation he was tortured and he was made to make those statements. Nowhere in the cross-examinations, Lordship can once again go to PW5. PW5 I have already shown. Nothing of that sort, that any force was applied, any coercion was done. They should have brought it in the cross-examination while questioning the SDPO. While questioning the SI, PW6, Lordship will see, I have already gone through the cross-examination, it is read out. There is nothing on record. I have placed one decision where it is said that only 313 will not do. Has to be somewhere else that some coercion is applied. And then Lordship, I like to place the decisions because there is not much evidence here. PW6 also Lordship can see there is nothing. PW6, he is the Montu Kumar Deka. He also had gone to, and Lordship will go to PW6 once because of his point on written authority. Lordship can go to page number 25. The cross-examination of PW6. I have already placed his chief where he had said that Mr. Hajorika gave me a written authority. Page number 25, during his cross-examination, the first line Lordship will see, before my departure to the place of occurrence, SDPO gave me a written authority in the police station itself to seize the bhang. He gave me the said authority letter before my departure to village Nahuria. I questioned Motilal Shah at his shop, he is some shop owner, but I recorded neither his statement nor the statement of any other person. Then he again reiterated in his cross-examination, we went to the village, although I found seized bhang in a place stated to be a godown, but the same were found in a safety tank. I did not find any evidence. He will not find any evidence that Pradeep Jha has done it. He has to say that what he said is Pradeep led us and we had recovered. Now, apart from that, he doesn't have evidence that it was Pradeep Jha. There's nothing wrong in it. He is not the person to see what evidence will be relevant and what not. What he had said is we went and we had seized. And Lordship will go to the last line at page 26. What he was saying is Pradeep Jha showed us the room. That is the room where they went first to Pradeep Jha's house. And there they interrogated. That is what was stated by this witness. Pradeep Jha showed us the room. No bhang-like substance was recovered from that room. In his statement made before me, Pradeep Jha stated that he did not own the bhang-like substance. This he will definitely say, I seized the 2 rupee coin and used as a seal. Then Lordship will go to the third paragraph. Last but 5 lines. The SDPO, the OC and others went to Pradeep Jha's house in the same convoy. Thereafter, our senior officials entered the bedroom. So I do not know what type of discussion we had in Pradeep Jha's house. I recorded the statement. What type of discussion? He did not say anything. This is a cross-examination. So nothing came out that there was some force. I do not know what type of discussion they had with Pradeep Jha. I recorded the statement of SDPO. I did not record the statement of DSP. So nothing on record. PW7, Lordship can skip. He had said I was not there and all. And then PW8, he is the intelligence officer. Of course, the intelligence officers, they had just accompanied the police officers. In fact, they were not very interested, it seems. They have not gone deep. What he said, I do not know who has seized the contraband. But I do not know what was the amount. On that day, we have seen some packets. Lordship can see at page number 35, the cross-examination of PW9, the intelligence officer from Guwahati office. Page number 35. What he has said that we were not interested, what kind of contraband we mean the NCB. So NCB people had just accompanied, they had not taken much interest. It was the police who had done it. Then, Lordship, I'll go to straightway to the judgments that I would like to refer. First judgment I would like to refer on 2000. I've sent the mail. Lordship can see it in the display board also. That is what we did in court number 7. Because
Okay.
but whether they can now operate is a difficult thing. Oh, acha. Now, okay, I mailed these judgments. 2015 6 SSC 222. I mailed it
How many
yesterday.
judgments have you?
Only possession, only one. Then the other judgment is that only police were witnesses because independent witnesses were not there and nothing to disbelieve the police. Here, police people have SDPO and the SI had said about the seizure. So there is nothing to disbelieve them on that, the second judgment. Third is torture. Only in 313 will not do. There has to be other materials. Then fourth is also on torture, same judgments. And the third is, what he is saying is he was not in custody. He was arrested later after the seizure. That will not matter because even surveillance will do. If a person is under the surveillance of the police officer, that section 27 will come into operation. The seizure, the recovery will be good. Only these decisions are placed. Lordship will first see the possession part. Now he has again stood up to say something.
No.
Oh.
What should I disturb you? Once you complete, then I will reply. What should I disturb you?
The first, I'll just read out slowly if they are taking time to take it out. On conscious possession, the first judgment would be only paragraph 16 and 30. This is 2015 6 SSC 222, paragraph 16 and 30.
2016?
2015 6 SSC.
Page?
222. This is a very popular judgment.
Para?
16 and 30. Lordship will refer to this Manupatra because otherwise again paragraphs will change. Mohanlal. This is a very well-known judgment of Mohanlal versus State of Rajasthan. There, the concept of possession is explained. Lordship will go to, oh, he has given SCC. Oh, Anisa. Paragraph 16, actually, Manupatra, it starts from the aforesaid exposition of law. The term possession. Paragraph 16, actually, paragraph, once possession is established, the court can presume that the accused had,
Which paragraph?
paragraph 16 in Manupatra.
One possession.
Hmm. From the aforesaid exposition will also do. I can take out, Lordship can send me the
No,
book.
no, it's a-
Acha. From the aforesaid
just
exposition.
a minute, just wait. From the para 21.
Acha. Actually, once possession is established is a quotation from the other judgment, Dharampal. Lordship will go to the sentence from the aforesaid exposition of law.
Yes, para
Yes.
21.
Acha, 21. From the aforesaid exposition of law, it is quite vivid that the term possession for the purpose of section 18 of NDPS Act could mean physical possession with animus, custody, or dominion over the prohibited substance, with animus, or even exercise of dominion and control as a result of concealment. The animus and the mental intent, which is primary and significant element to show and establish possession. Further, personal knowledge as to the existence of chettle, that is the illegal substance, at a particular location or site, at a relevant time, and the intention based upon the knowledge would constitute the unique relationship and manifest possession. In such a situation, presence and existence of possession could be justified. For the intention, it is to exercise right over the substance of the chettle or to act as the owner to the exclusion of others. In the case at hand, the applicant, we hold, has the requisite degree of control when even if the said narcotic substance was not within his physical control at that moment. Here it is, the entire house is owned by someone else, but the particular place, the contraband, he is in possession. He has the control over it. To give an example, a person can conceal prohibited narcotic substance in a property and move out thereafter. The said person, because of necessary animus, would be in possession of the said substance, even if he is not at the moment in physical control. The situation cannot be viewed differently when a person conceals and hides the prohibited narcotic substance in a public space. In the second category of cases, the person would be in possession because he has the necessary animus and intention to retain control and dominion. As the factual metrics would exposit, the accused appellant was in possession of the prohibited and contraband substance, which was an offense under NDPS, had come into force. So what we have to see is the animus, his knowledge that he had the control over the substance, he knows in exclusion of others. Renush knew, his wife knew, and he was the person who knew.
What is the difference between conscious possession and constructive possession?
In fact, I got no judgment on that. It is almost the same, but Lordship perhaps will know that a judgment I did not bring. Direct, perhaps physical possession. I'll get the judgment on constructive. I'd taken out. I thought I'll not place it today. So this is on
I thought you'll
possession.
not place it today.
No. I'll place it then. To the
You'll
constructive
place
and
it
this.
some other day.
No, today only. I took out, it will be in the, this, but I've not mailed it. So I'll go to that, but as far as possession is concerned, in my humble submission, he led, and the possession, as far as it is explained by the Supreme Court, it tallies, it fits it. The second judgment, Lordship will go to the police being the only witnesses. This is 2014 12 SCC 419. 2014 12 SCC 419. This is Madhu versus State of Karnataka.
Para?
Paragraph 10, 11, and 12. This is paragraph 10. I'll read out slowly, Lordship. Learned counsel for the appellants has vehemently argued that in some of the recoveries, though a large number of people were available, but only police personnel were made recovery witness. Thus, the whole prosecution case becomes doubtful. Now it is, they have deliberated. The term witness means a person who is capable of providing information by way of deposing as regards relevant facts via an oral statement, not perhaps the statement, or a statement in writing made or given in court or otherwise. Lordship will go to paragraph 10. Oh, this is SCC. Learned counsel for the appellants.
Learned counsel for the appellant.
has vehemently argued.
That's how it starts.
That's how it starts. Yeah, after
Just a
it-
minute, just a minute. This 2000. Mister, when you, please don't put this. If it's, because we tend to turn to the page where the bookmark is, okay? Otherwise you put it on the page.
2000.
419.
419. Even then, SSC has their own copyright.
Paragraph 10.
Learned counsel for the appellant.
Mr. LDV Raju. No,
No. Learned counsel.
that vehemently argued.
Vehemently argued.
Para 17.
Acha. What Miss Justice Surana told me that why paragraphs do not tally. According to Justice Surana, that SCC has their own copyright, has their own right. They make their own paragraphs.
Okay.
Other journals, they simply get the judgment and they publish it,
Okay.
according to Justice Surana. They did. These are from Manupatra Lordship, you can see here, these prints out are there. Now, Lordship will go to paragraph 10. The learned counsel for the appellants has vehemently argued. That is, their paragraph is different. Here it will be 10. For Justice Thakuria, it will be 10. Learned counsel for the appellants, Lordship project, has vehemently argued that in some of the recoveries, though a large
Just
number
a
of
minute, just a minute.
Lordship, yes.
This is.
Madhu. Madhu, turn to paragraph 10. Madhu, yeah, these are all landmark judgments. I'm not very expert in NDPS, so I've got those main judgments. Madhu
None
versus.
of us are, none of us are.
Miss Bhuya, she though, puts off her hand. No, I'll not go into NDPS matter.
Okay.
She herself makes herself free. Lordship will see 10. Learned counsel for the appellants has vehemently argued that in some of the recoveries, though a large number of people were available, but only police personnel were made recovery witnesses, thus the whole prosecution case becomes doubtful. Then the Lordship deliberates. The term witness means a person who is capable of providing information by way of deposing as regards relevant facts via an oral statement, a statement in writing made or given in court or otherwise. In Pradeep Mangaonkar's case, this court dealt with the issue of requirement of examination of independent witness and whether the evidence of a police witness requires corroboration. The court held that though the same must be subject to strict scrutiny, however, the evidence of police officials cannot be discarded merely on the ground that they belong to the police force and are either interested in the investigation or in the prosecution. However, as far as possible, the corroboration of their evidence on material particulars should be sought. Then Lordship will go to paragraph 11. Thus, a witness is normally considered to be an independent unless he springs from sources which are likely to be tainted, and this usually means that the said witness has cause to bear such enmity against the accused so as to implicate him falsely. In view of the above, there can be no prohibition to the effect that a policeman cannot be a witness and his deposition cannot be relied upon if it inspires confidence. Here in a case, this is not by police also. Here, Kolkata people have got the information. They inform the Guwahati people. Then they reach the police station. There is no enmity. Police will not, there's nothing to disbelieve. They will not like to simply be put behind somebody behind bars. So this is where it inspires confidence. Lordship can go to paragraph 12. This is where Lakshmibai's case is referred. Because things are said in a better way, so I'm referring to this. Furthermore, it cannot be in any dispute with regard to the legal proposition that if a party wishes to raise any doubt regards the as regards the correctness of the statement of a witness, the said witness must be given an opportunity to explain his statement by drawing his attention to that part which has been objected by the other party as being untrue. Without this, it is not possible to impeach his credibility. Such a law has been advanced in view of the provisions of Evidence Act, which enables the opposite party to cross-examine a witness as regards information tendered in evidence by him in his initial examination in chief, and scope of 146 and all are there. Why I'm referring to this? They did not bring out anything in the cross-examination. That the police personnel cannot be believed, the Caesar cannot be believed, the statement made was involuntary. All those things were never brought out in the cross-examination. So there is nothing to disbelieve the police officers as far as their statement is concerned. Then the next judgment, Lordship will go to Prabhulal, 2003, 8 SCC.
Regarding,
313 cannot be the sole basis for showing that he was tortured. Because he had shown only that, subject to correction if he shows something else. 2003, 8 SCC, 449. Paragraph 5. This is Prabhulal versus State Assistant Director, Revenue Intelligence.
again, Manupatra.
Again, manufacture. The book will be there. SCC for our advocates is too costly. It comes at around 75-80,000. So we resort to Manupatra Supreme today.
Per year.
No, while taking connection, they take around 80-90,000 per
Okay,
year.
the
just
initial, that's the initial.
Initial. Now it must have been increased, I don't know.
80 SCC when I was a lawyer also.
Hmm.
That time also it was 80,000.
Must have been increased. It must have.
No, no, it was
increased.
80,000 at that time. It's
Ah.
still remaining the same. Imagine at during our time it was 80,000.
Yes.
That was very costly. The
Ah.
initial payment that we made.
Mr. Mishra made that payment 2002, I saw. It was 80,000 something.
I think 88,000 or something. like that.
Ah, yes. So it is too costly, so we resort to these things. Manu, and India, Supreme today is also
Then you pay
Cheaper.
10,000 every year.
every year. Lordship will see 2003, 8 SCC 449. On 313, this is paragraph 5 as far as Manupatra is concerned. It starts with, it has been established. This is of course paragraph 5. This is a Customs Act. This
Yeah.
is a case under this one, but then the fact is that I'll place another judgment also. This starts with, it has been established that the Customs Office was about 20 kilometers. Lordship got it? Yes. From the place where the truck and the car were apprehended. Having regard to the large quantity of heroin, the said vehicles with accused number 2, 3, and 6 were brought to the Customs Office. Further, accused number 1 and 2 did not know Tamil. A Hindi knowing officer had to be arranged. There was under the circumstances no delay in recording the statement of the appellants. Thereafter, further, it is also to be borne in mind that the appellants did not make any complaint before the magistrate, before whom they were produced, complaining of any torture or harassment. It is only when their statements were recorded by the trial judge under 313 of the Criminal Procedure Code that a vague stand about torture was taken. Under these circumstances, the confessional statement cannot be held to be involuntary. Because here they went to section 67. And so it is said that it cannot be said. The statements were voluntarily made and can thus be basis of appellant's conviction. A similar decision, another one, 2011 SCC. Similarly, on similar point, 2011 SCC 347.
You said section 67 of the NDNPS Act.
NDPS Act.
What
where
does what does it say?
It says about taking statements of the appellant after they were apprehended. It is, I've come across few Supreme Court judgments saying it is admissible, those confessions, because rigors of 24 will not come. 67 on NDP. No. In rules, sir? I'm not so wrong.
67 is calling for document.
As well
That's
as
some
questioning
information.
the, I think questioning the accused. This is power to call for information. This is where confession and all were recorded. But
67.
Lordship can see an officer referred to in section 42. In fact, 42, those police officers, we have a notification also issued by Assam government saying that other officers can also do it.
That can, no, that
Ah.
can be done, but you have to identify those officers.
Officers
But
were
I
also,
think the 67 is for calling for information. It's not with regard to taking the statement.
explain,
Calling
examine
for
only person.
information or document.
No, examiners also there. Lordship will go to clause C. C also for A speaks that call for information. C says examine any person acquainted with the facts and circumstances of the case. There accused is also involved. Any person. But then 67 will not come in our case because police were there. So Lordship will go to the next judgment, 2011-11 SS.
Just a minute. Doesn't the police officer come under 42?
It
Yeah.
comes, it comes. And that is what even I'm not very clear. 42, many of police officers come.
Yeah.
But then again, 24 rigors, few of the judgments I've checked. They say when Narcotics Bureau people does the investigation, then 67 applies. Because they are not strictly police officers.
Correct.
And so here again, 24 will be applicable, no admission before police will be admissible. I'm yet to finish my research. I'm not very clear. No, according to him, they do.
Huh?
That according to him, they do narcotics matters. That even the confession is not admissible, it is said under 67.
That the statement recorded under section 57 will not be.
That
Recorded
is
by
fine.
whom? Recorded by anyone? That will be treated like a statement recorded by. 161.
160. No, that is why I've said my research is not complete. I'm not. Once in again, no police.
Okay, but what about statements made to police but made to customs officer under the Customs Act 108?
That is as per the act, it is
As per the act, it is admissible.
because customs officer were never considered as a police officer.
Correct.
In view of the Police Act of 1861. also.
So under 42 of the NDPS Act, customs officers are also the empowered officers.
Empowered.
Then what will be the effect?
Now,
of
if they,
statements made?
Lordship, if they investigate as per the NDPS Act,
Ah.
then again 67 will be applicable upon them. But if they register the case under the Customs
Customs
Act,
Act.
then it will be different. Then again, they will not be able to arrest it because customs are available. That will be a difficulty for them.
Customs Act are available.
Available. So they will definitely come under NDPS.
I have to see this entire aspect. I've not seen.
If my senior colleague will complete today, then I will give a reply.
Completing today. There are only 2-3 judgments that I have to show. The next judgment, Lordship will see.
No, no,
2000
no,
Oh, no, there are.
correct.
Yeah.
Yes, this 2011.
11 is also on that, only 313 will not do. 2011,
No,
11
which para?
or paragraph 13 of
How
Manupatra.
how does it
It starts with bearing in mind the principles aforesaid.
bearing in mind, bearing in.
Paragraph 13 in Manupatra.
347. no?
Acha, acha. It's a long judgment. Yes.
Para 17 out there.
Acha. Para 7. Bearing in mind the principles aforesaid, now we proceed to consider the facts of the present case. Appellant's first confession was recorded on so and so. This is also a case on 67 only. Jagdish Mawal, and he was produced before so and so. He made no grievance in regard to the confession recorded. Another confession was recorded on so and so, and thereafter he was produced before special judge. This obviously would have contained the confessions made by him. No complaint about the same was made then also. Thereafter, the appellant was produced before the court several times, but he never retracted his confession. The appellant retracted the confession made by him for the first time in his 313 statement. In our opinion, when an accused is made aware of the confession made by him and he does not make complaint within a reasonable time, same shall be a relevant factor to adjust as to whether the confession was voluntary or not. Here in the present case, appellant was produced before the court on several dates, and at no stage he made any complaint before the special judge of any torture or harassment in recording the confession. It is 2011. It is only when his statement was recorded under 313 of the CRPC, then he retracted and denied making such confession and went to the extent saying that his signatures were obtained on blank pages. In the facts and circumstances of the case, we are of the opinion the confessional statement made by the appellant were voluntary in nature and could become the basis for conviction. The view in this support, Prabhu Lal, the same case they have again referred to. So he should have said somewhere at the earlier point of time, but never in 313 he only said. Then the last judgment on surveillance. This lordship has to see Manupatra because it is a High Court judgment. Division bench, Allahabad High Court.
Yes,
The Allahabad High Court judgment lordship has to see. That is from Manupatra. This is Sangam. Dilip, heari. Eta aru eta copy lo. Sangam. Sangam to say, eta aru eta copy lo. Sangam versus Sangam Lal versus State of Uttar Pradesh. Oh. The last judgment. Sangam Lal. There it is said even surveillance will do. Paragraph 1890.
surveillance of what?
He is under the surveillance of police. He may not be arrested. He is not strictly in custody, but in surveillance will do. He was apprehended, then he was taken, so he was definitely under the police surveillance. This is paragraph 1819.
Long judgment or short judgment?
Not very short, not very long.
You see, there's no point
26.
printing out so many pages.
Not very long. But you can see only 18 and 19 paragraph can be taken out.
Well, we are wasting a lot of paper.
This happens, but 18 and 19 page 2 later, paragraph 2 later. One you take out, one. This display should be made workable. This helps. Justice Surana is doing that. I did one debt reference matter. There we did it. Paragraph 1819. We did it. I placed around 20-25 judgments, so we have done it that way. I can read. Lordship has another computer there.
No, this is for, I'm looking at myself from there.
Oh, acha. No, that can also be taken out, I think, there. This is only for videos, I think.
They help me comb my hair.
Yes. 1819. I'll just read out.
Just a minute, what is the citation?
This is Manupatra UP 115-2001. Sangam Lal versus State of UP. What we do in the chamber, we take out the first page where the citation is mentioned, and then we take out the relevant page when the judgment is too long. First page, first page.
18 and 19.
18 and 19. In Chote versus State of UP, the court, after referring to the aforesaid decision, observed that there is distinction between an accused being under arrest and an accused being in custody. In Ramchandra Air 1960, it was ruled that interpretation of the word custody in various decisions has proceeded insofar as to suggest that police custody in terms of section 27 might well include surveillance, interrogation before arrest, etc. Where a person submits himself to the custody of a police officer with the consciousness that temporarily at least he is in such custody or such control, whether formally authorized in some manner or otherwise. This question has been considered threadbare in the Constitution Bench decision in Deoman Upadhyay. This one I found it more better, so I brought it. Deoman Upadhyay, it is quoted, there is nothing in the Evidence Act which precludes proof of information given by the person not in custody which relates to the facts thereby discovered. It is by virtue of the ban imposed by 162 of CRPC that a statement made to a police officer in course of the investigation of an offense under chapter 14 by a person not in police custody at the time it was made, even if it leads to discovery of a fact, is not provable against him at the trial of that offense. This one will also do. But a distinction which, it may be remembered, does not proceed on the same line as under Evidence Act, arising in the matter of admissibility of such statement made to the police officer in course of an investigation between person in custody and person not in custody, has little practical significance. When a person not in custody approaches a police officer investigating an offense and offers to give information leading to discovery of a fact having bearing on the charge which may be made against him, he may appropriately be deemed to have surrendered himself to the police. Section 46 of the CRPC does not contemplate any formality before a person can be said to be taken in custody. Submission to the custody by word or action by a person is sufficient. A person directly giving to a police officer by word or mouth information, which may be used as evidence against him, may be deemed to have submitted himself to the custody of the police officer within the meaning of section 27 of the Evidence Act. Paragraph 19, the well is therefore well settled that in order to attract 27 of the Evidence Act, it is not necessary that the accused should have been under arrest, and it is enough if he has come into the hands of a police officer or is under some sort of surveillance or restriction. A person giving information to the police officer may be deemed to have submitted himself to the custody of the police officer within the meaning of section 27 of the Act, Evidence Act. Therefore, the contention raised by Mr. Mishra cannot be accepted, and the information given by appellant leading to discovery of the incriminating articles referred to above is fully admissible in evidence.
No. So what do you want to show by way of this judgment?
No, what he said that he was not in custody, he was arrested after the recovery of this contraband. So he will, it leads to what? That 27 will not be proved. 27 is not complied with. Because 27 says a person in custody of a police officer gives any information. And custody is explained. He may not be arrested, but if he is arrested, that is why I'm placing them. These are my humble submission. That an inventory, as I said, this is, I forgot the case name. It was only directory. Of course, that needs to be followed by the police officers. But the fact remains that it is directory. It need not finish off my case. Authorization in letter was there. It was stated by so many police officers. And therefore, the seizure is proved. It was in his possession. He had the exclusive knowledge. 27 is meted out. And therefore, I don't see any wrong in convicting this person. And there is no coercion and all, only when 313 will not suffice. These are my humble suggestions.
Now, first of all, the judgment which I placed before Lordship.
Hmm?
The judgment which I placed before Lordship yesterday regarding the voluntariness It was in 2009. Lordship, may kindly have a look of the quorum of the bench. It was by a 5 bench.
Just a minute, what judgment did you place before that?
Just a minute.
I don't have any judgment before me. Do we have? Okay. 2000. Nineteen 99, we don't have any.
99.
No, just-
আৰু এটা দিছিলা, দুটা দিছা ন?
no, it was-
মইনুল হক। মইনুল হক। মইনুল হক।
Yes, yes.
Yes, Lordship's judgment. Sitting with Justice Mridul Kumar Kolita.
Okay, no, he's talking about a Supreme Court judgment.
I had given one more judgment.
No, we have got only two judgments.
Yes, yes,
99
yes,
agencies.
yes. One is 99.
One is 99 and one is the division
Yes.
bench judgment of.
Yes, sir.
He's referring to 99.
May I submit one? The contention that has been placed by the prosecution now, Lordship, is in fact not founded on the record. Why I'm saying it's not founded on the record? Because there are too many contradictions in the statement of the PW. If we take for a moment of time, first and foremost, prosecution has said that NCB was not interested. Perhaps that submission cannot be made because everything has been floated out from the information of the NCB. Now, NCB's officer, Samantha Swarupa, he said that this particular contraband was in fact pointed out by one of the informers. Now, that informer is not before the court. That informer was never recorded. That informer was never examined. That is one part. Second part, Lordship will kindly see that it has come in the prosecution case itself that the appellant was first picked up, then interrogated, then he led. Now, had he, I'm giving another circumstance, Lordship, had he, the moment he has been picked up or arrested or detained, moment he would have directly gone there. I would have
You would have
understood.
directly?
Gone there, the place of recovery, I would have understood. He was taken back to the police station. From there, he was taken to the place from where they say that they have made a seizure. But in fact, our case is this, that no seizure has been made. Although other witnesses are saying that seizure has been made, where is the contraband? The contraband has to be.
No, but then that proposition would entail us to decide whether you're telling the truth or she's telling the truth.
Record will speak, Lordship.
Huh?
I am on the record. Because I can't say anything beyond the record, neither the prosecution can go beyond the record. Prosecution has examined 12.
So why should we believe you and not believe them?
No, I'm not saying. I'm not saying that to believe me or to believe the prosecution. What I'm saying is, we have to believe the record,
Right?
the evidences.
Huh.
Evidences says, I'm absolutely on the evidences, Lordship. I'm not on anything else. The evidences say the prosecution case is totally contradictory to one another. One witness is saying one thing, the other witness is saying other thing. If your Lordship just look into the IO who has filed the charge sheet, we have to believe the IO, Lordship. There's nothing to disbelieve the IO. The IO said there is no authorization letter. He himself said, and even in one evidence, if I recollect it correctly, then this SDPO himself said that. No, that's not, leave it to it.
How much time will you take?
Sometime, because I have to give reply. I will take your Lordship to pinpoint those.
No, no, sometime is very
15, 20
subjective.
minutes, maximum 15-20 minutes. I have some citations to produce with your Lordship. 3-4 citations,
You confine yourself to the time period.
15 minutes. Sir.
Huh?
Maximum 15
15.
to 20 minutes, not more than that.
You see, there's no point going round and round.
No, not at all. I will be absolutely in the point where I was from the day one. From the day one where I was, Lordship, I will be there. I have been consistently saying one thing. Your Lordship has already read the facts.
We'll take it up at 2, then you'll be ready at 2. Then where you confine yourself to 15 minutes.
Lordship. I'll give some citations. That one. Okay. Yeah,
Explained in Mohanlal case itself, not explained to that extent, but what I can see, there's a thin line of difference. Constructive possession, actually the difference is between actual and constructive possession. Actual is actually having his possession and constructive is having control. And conscious possession was brought in by section 35. Conscious possession is having the mental state, he is aware. So aware and having control. So that is the thin line of difference. Mohanlal case, paragraph 9.
So
and
that
11.
is why actually the word should be constructive.
What should be having control?
The word is constructive possession actually. As constructive will include within its fold conscious.
Conscious. This is what section 35 of the, and Mohanlal 11 and 9 paragraph, lots you can see that difference. Mohanlal 2015 case, paragraph 9 and 11. 9 is on constructive, 11 is on conscious.
Para
9
is on
constructive. And 11 is on conscious. Awareness, culpable mental state, what they said,
para 11 on conscious.
conscious possession.
So can it be said that a person who's in conscious possession is also in constructive possession?
Yeah, that's what I think so, because most
Why?
of the cases,
Why?
he is in conscious and constructive possession.
No, why not?
He,
But what is the meaning of conscious possession?
conscious is, he is aware,
He's aware. Constructive will be having
control.
control over it. So
Yes,
that's the
there can
difference.
be a difference.
See, so while constructive possession would include conscious possession,
Hmm,
conscious possession might not
yes,
include
might not include,
constructive.
yes. Like in this case, Rinush has conscious possession, but I think Pradeep Jha has constructive possession.
No. I beg to
I
differ.
know, it depends on,
I beg
Rinush
to
is not before.
Because Lordship will kindly see, as the Lordship just said, in case of conscious possession, the animus, that is the intent to possess, should always be there. And therefore 35 and 54 are one dependent.
If he's in conscious possession, that means he knows it is.
Yes. That is what I'm saying.
Mhm.
In case of conscious possession, the animus, that is the intent to possess, has to be there. And it is the burden of the prosecution to prove that it was there. That I will show from the record. I will just take.
Okay, you got 15 minutes.
Lordship. I won't take that much time also. Now here, Lordship, I have just made some so it's easy for us. Here there are 12 PWs, Lordship. PW6 is the informant. PW8 is the de facto informant, I would rather say, because he was the intelligence officer from Calcutta who has sent the information and who has also participated in the raid, that was the LS raid that has been conducted. Now, PW6 was the informant come the seizing officer. Now, PW6, Lordship will kindly see in the seizure memo, there are 3%, other 4% participating in the seizure. 2 witnesses, independent witnesses who could not be found out. One Montu Deka, who the prosecution now do not want to rely. And another is the person who seized, that is the informant himself. Now, only person who is saying that there was a seizure was the informant. Lordship will kindly see. And another person, Lordship, is PW5. He happened to be the SDPO. Now, SDPO says, Lordship will kindly see, I have not put signature in any of the seizure or in any proceeding during the operation. But he says that he was present. Now, this casted out. If he was present, he is the only person, Lordship.
Who was present?
SDPO PW5. He said that I was present, but I did not participate. Now the question is where he was present. Within the premises of the place of occurrence or else somewhere. Or he was just there and he did not see anything else. Then his statement will perhaps not be corroborating the statement of PW6. Other seizure witness, there are no other seizure witness. If I may kindly conveniently say from the record. Now, Lordship will kindly come to Storup Samantha for a moment. Lordship. Before that, Lordship will kindly see page 22, that is the cross-examination of Montukumar Deka, the informant, who has participated in the part of the investigation. He said one thing: I never gave any option to the accused person nor served any notice upon them, asking them whether they felt it necessary that a magistrate or a gazetted official should be present there. So there was no magistrate or a gazetted officer when this alleged search was carrying on. It is from the mouth of the witness itself, Lordship. Then Lordship will kindly see
No, this is the evidence of whom?
Montu Deka, the informant. He
What does-
conducted the search.
What does
Lordship.
he say?
He said, page 22, Lordship. I neither gave any option to the accused persons nor served any notice upon them, asking them whether they felt it necessary that a magistrate or a gazetted officer should be present there. Your Lordship is kindly find it. Lordship.
So?
I'm coming to that now. Lordship. Now, Lordship will kindly see again. PW 12, that is the IO who has filed the charge sheet.
Page?
Page 40, Lordship. I am on page 41 now, the last portion. May I, Lordship? May I just read that, Lordship? The original authority letter empowering SI Montu Kumar Deka to take up investigation and recover the NDPA substance in connection with Madhvat PS GD number 11 dated 1/4/15 is not found neither in the case diary nor with the document attached with the charge sheet. So, Lordship may kindly see what I'm trying to satisfy this honorable court, that there was no seizure at all. Now, to prove the seizure, as contended by prosecution, Lordship, there is now only 2%, PW 6 and PW 5, because the seizure witness could not be found out. The other UBC, he made a statement which is not supporting the prosecution case. So there is a doubt. Therefore, Lordship, I will say that prosecution could not establish the seizure. Now, what the law says, Lordship, I have got certain citations in this regard. Lordship will kindly see. First, I am on Sanjit Kumar Singh versus Munna Kumar Singh. The last page, Lordship. Paragraph 33A. It is true that section 54 of the Act raises a presumption and the burden shifts on the accused to explain as to how he came into possession of the contraband. But to raise the presumption under section 54 of the Act, it must first be established that a recovery was made from the accused. Your Lordship, I still contend that no recovery has been made from me. The moment a doubt is cast upon the most fundamental aspect, namely the search and the seizure, the appellant in our considered opinion will also be entitled to the same benefit as given by the special court to the co-accused. 34 says, Lordship, in view of the above, we are of the considered view that the appellant is also entitled to the benefit of doubt. Therefore, the appeal is allowed. The judgment of the special court as well as the High Court insofar as the same relates to the conviction of the appellant as set aside. This is one judgment, Lordship, I kindly have a look. Then another is the judgment of Nuraga. Same thing on the burden of proof, Lordship, of the seizure. Paragraph 58, page 450. Page 450, Lordship. Paragraph 58. Section 35 and 54 of the Act, no doubt, raises presumption with regard to the culpable mental state on the part of the accused, as also placed the burden of the proof in this behalf on the accused. But a bare perusal of the said provision would clearly show that presumption would operate in the trial of the accused only in the event the circumstances contained therein are fully satisfied. An initial burden exists upon the prosecution, and only when it stands satisfied would the legal burden shift. So here again, I am on that, Lordship, that here the prosecution has in fact failed to first show that there was a seizure from him. Then Lordship will kindly come to have a look our own High Court judgment. Malbir Khan and another. Here, in fact, here my senior colleague was appearing for the state. But it. Anyway, it hardly matters. So here, Lordship will kindly see page number, para number 23, Lordship. Page number is 10, Lordship. Law, shall I read, Lordship? Law is well settled that even a case coming with the ambit of NDPS, the prosecution would be duty bound to prove the charge beyond reasonable doubt. In case of Nuraga Supra, the Honorable Supreme Court has observed that the initial burden to prove the charge lies upon the prosecution only when it stands satisfied that the legal burden under section 54 of the Act shifts with a view to bring within its purview the requirement of section 54 of the Act, the element of the possession of the contraband has to be established so as to shift the burden on the accused. Similar view has been expressed in the case of Gangadhar, wherein it has been observed that presumption against the accused of culpability under section 35 and 50 of the Act to explain possession satisfactory are rebutable. It does not dispense with the obligation of the prosecution to prove the charge beyond reasonable doubt. Now, Lordship may kindly have a look at paragraph number 28. This is what I am on. Because here also the same thing is operating. Page number 11, Lordship. We are no doubt in agreement with S. Jahan, and excuse me for the same, learned APP Assam, that independent witness is not a sine qua non for proving charge brought against the accused person under the provision of the NDPS Act 1985. However, evidence adduced by the official witness must not only inspire the confidence of the court, but should also establish each link in the chain of circumstance to prove the charge brought against the accused beyond reasonable doubt. Once the presumption succeeds in leading evidence to the prima facie established conscious possession of the contraband, it is only then the burden under the section 35 and 54 of the Act 1985 would shift upon the accused person. So, Lordship, here also there are contradictory statements of the witnesses. If your Lordship kindly look into all the 12 witnesses, almost none of them, only 5, and 6 himself as a Caesar witness, Lordship. How far his statement will be reliable, that the Lordship can look into. Because 5 is saying, Lordship, had 5 participated in the proceeding, matter would have been different. 5 is saying, no, I did not participate, I did not put my signature anyway. So only left person is 6. He himself is the informant, Lordship. Now, Lordship may kindly have a look into another judgment of our own High Court, Lordship. Munna Mushahiri. This is on contradiction. Maybe. Paragraph 18, Lordship. Page 8, Lordship. The learned counsel for the appellant regarding contradictions relied on the decision of the Honorable Supreme Court in Krishna Chand versus State of Haryana Supra, wherein it has been observed. It is settled law that the testimony of the official witness cannot be rejected on the ground of non-corporation by independent witnesses. Though in the present case, the prosecution support of its case has examined the complaint PW6 and Umesh Kumar PW4, who have supported the alleged recovery of the charas from the accused. However, there are material contradictions, as pointed out in their statements, which make the prosecution case highly doubtful. In our considered view, the High Court, by not taking into account the contradiction in the evidence adduced, held that in case there are minor contradictions in the depositions of the witnesses, the same are bound to be ignored and convicted the appellant as aforesaid. In view of the material contradictions which have come on record, we find the High Court wrongly convicted the appellant as the evidence adduced by the prosecution was not carefully scrutinized by the High Court, whereof the considered opinion that the High Court committed error in convicting and sentencing the appellant. So here also, Lordship, I would say that there are material contradictions, apart from the fact that there are other hostile witnesses also. Now I would come, Lordship, to 313. This is, I'm relying upon this judgment. This is from our own state, but it's a Supreme Court judgment. Rina Hazarika versus State of Assam. 2019, 13 SSC, 289. Before that, Lordship, I would like to submit that the appellant was never produced before any magistrate. After recovery, he was straightforwardly arrested. He underwent trial, then he was convicted, and this honorable court for the first time released him on bail. His statement under 164 was never recorded. So he had no option, any other option to state before any magistrate that my statement as recorded, as said, was involuntary. So now, Lordship may kindly see 313, it is here, para number 19, Lordship, page 295. Section 313 CRPC cannot be seen simply as a part of audi alteram partem. It confers a valuable right upon an accused to establish his innocence and can well be considered beyond a statutory right as constitutional right to a fair trial under Article 21 of the Constitution, even if it is not to be considered as a piece of substantive evidence. So here I am on Lordship. Now, Lordship, for a just limited purpose, I'd like to show your Lordships the statement of Rinush, just two statements, Lordship, recorded under 313 only. What Rinush stated before the court. The co-accused. Lordship may kindly come to page 46, Lordship. Answer to question number 3. I do not know accused Pradeep Jha. I know nothing about the matter. And there is no evidence on that.
Where are you reading?
Page 46, Lordship, of the paper book. Answer to question number 3. May I, Lordship?
Yes.
I do not know accused Pradeep Jha. I know nothing about the matter. Now, Lordship, there is no evidence on record to prove any CDR. There is no CDR.
Any?
CDR, call details record of any conversation between Rinush or Pradeep Jha during the entire trial or investigation. Now, Lordship may also kindly take page 47, Lordship. Answer to question number 6. There is no tank at my house. He has adduced false evidence. He denies. Rinush, this is the statement of Rinush, Lordship. Now, Lordship, the last judgment to place before Lordship, that is T. Thomas versus State of Kerala. That is on 41 surplus 2. Para 6, page 619. So Lordship has kindly got it. This sentence starts with section 41 to requires. Section 41 to require such authorization only if the officer of gazetted rank specified in subsection wants any other subordinate officer to him to conduct the search. Here, the search has been conducted by PW6, who is a sub-inspector. And the IO says,
This is with regard to search in the enclosed space.
Lordship,
Because it was
saying-
a tank.
yes, that is why I'm saying. They are saying it's a tank behind the house of Rinush. Rinush might have said no. And PW12 says, Lordship, who filed the charge sheet, he says no, there is no authorization there. They are all the prosecution evidence, Lordship. I don't have any evidence. I have not examined any witnesses. So I find there is nothing to disbelieve the prosecution evidence. So on basis of that, Lordship, I say that in fact, neither any constructive possession or any conscious possession from me has been proved. Therefore, I am entitled to be.
Yes. Where is the authorization letter?
Yes, of course, it is not exhibited, but
Is
the,
it there?
but then the PW5 and 6, they have said about the authorization letter. One said it was before he approached, before he started to the place of occurrence, he was given. This one, page number 25.
No,
PW6.
Can
it
you
is-
produce it?
Perhaps it will be there in the case
No,
diary.
now, if I may submit one line, Lordship.
Now,
Not,
you cannot-
PW5, SDPO Bhelgaon, he himself was examined as a witness. If he has given the authorization letter, prosecution could have easily exhibited through him.
No, it doesn't matter. Just because it hasn't been produced earlier, doesn't mean that it cannot be produced now.
No, I'm not saying this.
So let us see.
because this SDPO had also said that I had given the authorization letter.
Then why should we disbelieve the IO Lordship? He says it is not in the case diary, nor in the charge sheet.
So let us see the record.
Yes, yes. Honorable Court may kindly.
If it's not there, you produce it. Was any cross examination done to that effect with regard to authorization
Here for
letter?
the records, it is not,
No,
Not
not done.
no. I was not a counsel out there, Lordship.
Cross-examination was done.
But
With
not
respect
to-
of,
With regard to this authorization.
authorization letter, then he said that
It is
it
there.
was given, not to the
No, no,
police
no.
office, not to the IO.
Ma'am, you are going beyond the record. Cross-examination was done to the IO Lordship, and the IO says it is not on the record. It is from this
No, they just
cross-examination.
give it to, they just give it to. Let's see the authorization.
IO said not in the record, but PW6 said it was issued to me in the cross-examination.
PW6 might have said, he also could have exhibited his Lordship. Because he was aware of the SDPO signature. PW12 says it very clearly. And in that case, Lordship, I would pray. May I make one submission, Lordship? Supposing this authorization letter is found out here. Supposing. And it has not been exhibited. Then I would pray that let the matter be remanded back. Let it be exhibited, we'll cross him. We'll cross him on this aspect. Because IO is saying it is not there. It's not on the record, not on the case diary. And SDPO said that my statement has not been recorded by the IO. I was not examined by the IO.
Authority letter is there. Number one,
Yes.
Xerox.
Xerox. Generally, authorization letter is always there in the backside of the charge sheet. Lordship.
Authority letter seems to be here. I've seen in a table of contents, but it's a Xerox copy.
Doesn't matter if it's Xerox. And you're using the wrong word. It shouldn't say Xerox. Because Xerox is the company name. It is the Xerox machine. It's actually a photocopy. Whether you have
We loosely use this thing and I
used
sent her.
because Xerox was the company that was the only one
Hmm.
doing the photocopy in the initial stage. Then that name of these photocopiers, other photocopiers came into existence. But we still carried on with the original name of Xerox. Ah.
I sent her, I don't know.
Xerox has made a brand new machine.
Ah,
But Lordship, I will have a submission to Lordship for your Lordship consideration. If it's a photocopy, it's not been exhibited. Now at this stage, I will be highly prejudiced in that case. In that case, I will be losing my opportunity of cross-examining those witnesses who might have issued it because
but
SDPO,
what about the fact that the gazetted officers were there along at the time of the search?
but he said that he did not participate. It is from his own mouth.
Participate in what aspect? Then what was he doing? Just for
What was he
sideshow?
doing? Correct? Then he said it is from his own mouth. I did not participate in the proceeding. Whether he was really there or not, also not known. Lordship knows these things. It happens. It's a police investigation. We can't say. Then what precluded the trial court or SDPO Herga when he was examined before the trial court? He could have easily exhibited his document. He has not done it. Montu Deka, PW6 has not done it. The IO has not done it.
This is the one, Lordship can see.
If it has not come with the charge sheet, Lordship, then also I miss an opportunity of getting a copy of it.
Few lines written by the SDPO, I think.
I should get a copy.
Did you?
Yes, he is SDPO, PW5 Lordship.
So it seems he has given an authority letter, but where's the signature?
No, it's a.
Nirupam Hajarika.
Anyway, it seems it is there.
It seems.
What we will do is,
Apa dia sekolah? If it is done for the same process, section 135 make yes, yes, that provision too, if it is by the same process and all. No, it's secondary evidence.
where have you said in the evidence that the authority letter is not there?
Yes, Lordship. Lordship, may
Okay,
kindly
the
come to
IOs
page number 41, Lordship. Of the paper book. It is
Yes.
the evidence of the IO, Lordship.
Yes.
Last part, Lordship, may kindly see. The original authority letter empowering SI Montu Kumar Deka to take up investigation and recover the NDPS substance in connection with so and so is not found either in the case diary nor with the document attached with the charge sheet. Might be because of this photocopy, they could not exhibit it. Because it was a photocopy. The original was not there.
It was kept by in the pocket by some police officer
No, no,
there.
no, no. Generally, what they do, Lordship, if I may just make a submission, I may be wrong, but what procedure I've seen. Lordship, police always have a supplementary case diary with them. They keep it, they carry it when they go for giving statements. Sometimes what they do, some document they either inadvertently or whatever, they keep it inside. And might be because the PP did not assist in proper manner, they did not forgot to bring it out from there. Most of the time I've seen the trial court, they're carrying another case diary from where they used to say. Because the case diary is sent to the court moment the charge sheet is filed. Okay.
It search for in that color for posted to everyone.
Is it bail or jail? He's in jail, Lordship. 991 days.
How much?
991 days.
The whole day?
I am at a mercy before your Lordship. Even if 41 is there, Lordship, even if, suppose I contend that 41 is there, even if it is there is no recovery, Lordship.
No, anyway, we'll take one thing, one step at a time, because the thing is that we could have decided the matter if this photocopy was not here.
But then photocopy cannot be exhibited, Lordship.
No, that's fine. It appears that the original might be somewhere. Could be. So we'll have to see.
Report that somewhere, Lordship, I will be behind the bar for a long period of time. Oh. May I make a submission, Lordship? What thing can be done? It will be very easy. Let the IO be directed to produce this original before this court itself. Otherwise, Lordship, I am languishing in jail and my
Cross-examination.
cross-examination.
Nothing can be done if it is produced here. Now, what prejudice is caused? The Lordship has to see. What prejudice is caused by not exhibiting the original? And moreover, Xerox,
If it is coming out
photocopy,
from the,
if
out of my learned friend,
No,
then
no, you see, what?
T. Thomas says something else.
Huh?
T. Thomas says something else.
No, what he's saying is that when a person who is not authorized to do the search,
hearing on the other day without the documents, no FIR, no postmortem was exhibited, Lordship had remanded the case following that Mizoram's case.
Remand part is all that. I am not objecting to that. The question is, Lordship, I am behind the bar. And my health condition is very bad. That is the point that I am placing.
that is a different aspect, Mr. Counsel, that you can, there's no bar for you to file an application. There's no bar. Unfortunately, you're not filing it. We cannot look into
No,
that
my-
aspect.
Petition has been rejected, Lordship, by this court. That is why I did not file. This court has given me
Just
bail
because
on,
it has been rejected once doesn't mean that you cannot file it a second time.
Now, it was also observed in the order,
That it is
which is
health
required. They cannot be
so
filed.
when it was rejected, his health condition really improved. But now it
When it
was
was rejected, his condition improved.
improved because he just came back from the hospital, Lordship. Court gave him 1 month interim time to
Ah.
come back from the hospital.
Okay.
So he went to hospital, did his treatment and then he surrendered.
Diabetic, no, you said?
So yes, diabetic, less of
So,
ITI.
so actually jail food would be better. No sugar, nothing, I mean, no oil, basically a lot of water.
But they, the complaint is this, that they give a lot of potatoes, which is very dangerous.
Okay, sugar, lot of sugar.
So the only option perhaps is to remand the matter, let them again
Yes.
produce the
I
original.
think for the, let them give the chance.
In that
to
case,
that.
Lordship may kindly fix a time frame. Lordship. Because original was not there at that time. Lordship will kindly
No,
see.
no, I've noticed, 2016, the issue has been brought up by the thing. Unfortunately, this issue is here. What did the trial court say with regard to this issue?
Nothing, nothing. I did not find anything, Lordship.
Did not see.
Trial court,
At the end of the day, his basic case is that
trial court
violation
is
of
saying what the
mandatory
Lordship has
provision,
just
that's all.
observed. Trial court is saying, Lordship, in page number 101, paragraph number 87, as a Lordship is just saying that as because SDPO was himself there, therefore the requirement of 41 surplus 2, as in 41, 42 surplus 2, is not so much fatal. That is what they are saying. But since no personal search of the accused Pradeep Jha and Munish were made by PW6, so he need not comply with the provision of 53, though PW6 Monty Decker did not record the reasons for satisfaction. That is the observation of the trial court.
Okay, right. Heard Mr. A. Bhattacharya, learned counsel for the appellant. Also heard Mrs. Jahan, learned additional PP for the state respondent. Hearing concluded, judgment reserved.
On this non-exhibition of the authority, original copy, it's in paragraph 84. 84, sir. Copy, though not original copy was exhibited, Nirupama has not exhibited, but it is well settled under 294 because investigating officer listed the documents prepared by him during investigation and kept the same in such form as prescribed by the state government. 87 course. 8 to 84. 87 is personal, sir.
Whose book is this? Yeah.
Yes,
Yes, yes.
Lordship. Lordship. Sub Inspector, Police. I think Lordship, inspectors are gazetted, sub inspectors. I'm not so sure, Lordship. Whether they now comes under the category of gazetted officer or not.
Gazetted. SIs are gazetted.
Yes, gazetted. People.
Can you put like somewhere?
No. Give it nothing to nothing. But I can find it out, Lordship. Whether they're gazetted or not.
You also find out and you get them, madam.
I can find it out. Then there will be some notification, I suppose, of the government of Assam. If they're gazetted. I'll try to find it out.
Ah. 89.
Yeah,
As the paper book has been made.
Yes, it's ready.
the appellant was convicted under section 4 for.
We are on the 389. Or we are on the main case.
I has come.
I has come up.
No, but why do we dispose only the IA? Why can't we dispose of the entire thing? Why do double exercise twice when it can be done once?
For appeal, your lordship has to go through entire record. And for IA lordship, the simple issue is their lordship. But if your lordship finds that she is minor, then probably my case is not there. My admittedly, it is there.
If she's minor,
No, in the present case. Present case, they did not produce any documentary evidence. And doctor's medical evidence is there that your lordship will find page.
what is this, under
4.
POCSO?
Page
POCSO.
75, doctor's report is there, your lordship will find that doctor opined that she is between 16 to 18 years. And she admitted in cross examination that there is a probability of 2 years plus minus on either side.
She admitted,
That doctor
admitted.
admitted. And the doctor also admitted that in the medical report that there is no sign of recent sexual intercourse within
there is no sign of,
recent sexual intercourse within 72 hours. And
and
immediately after was called-
incident occurred when?
incident occurred on 5. 24/10/2018.
24/10/18. And FIR filed on
Same day.
same day. And doctor's report made on
Next day.
25.
24. Page 75, your lordship will find.
Page 75. Yes,
Relevant portion I am referring, lordship will find. Page 79. Page 79, serial number 22.
79/22.
Opinion. On the basis of physical examination, radiological laboratory investigation done on 25/10/2018, I am of the opinion that the victim is above 16 years and below 18 years from radiological evidences. There is no signs of recent sexual intercourse. And her evidence is PW3. That doctor.
What is the report on the hymen?
Hymen healthy, it is said.
Healthy means it is still intact.
That is not reflected in the report. So, page 77, column 16.
Yes, it says healthy.
Healthy.
Healthy means what? Intact.
Probably that.
Naturally, if it's not intact, it won't be healthy.
And from
And
her
from-
evidence also appears that immediately her mother came and she saw.
But leaving that aside, what is the case?
The case is.
Your submission is only with regard to age,
Case and as well as there is no incident occurred.
no incident.
No incident, because the allegation is that when the victim went to the bathroom, immediately the accused also went there and forcefully committed rape. This is the allegation. And after some time, mother came and saw both of them. That the accused was
Lying on top of her.
jumping over to another room of the bathroom. That to latrine, adjacent latrine. And he came out from that. So,
What is the relationship between them?
they are neighbors.
Neighbor.
Neighbor. And accused was 20 years old at the time of incident.
20 years old.
20 years. And from the evidence of PW5, your lordship will find that immediately after 5 minutes, her mother went to the place of occurrence.
Immediately after that,
Immediately that the victim went to the bathroom and after 5 minutes, her mother also went
Okay.
there.
Was also
So
on
the
the way
fine.
to the washroom.
Huh?
She was also on her way.
Way to the washroom. actually.
And he
And then
is
she
in,
saw.
for 18 months, that is more than 2 years, almost about 2 years. He is in custody.
let us see her evidence.
That PW5. Page 15.
11:30 AM.
Yeah.
What is it? Let us see the evidence of the mother.
The PW4. Page 12. In cross of victim at page 16, first line, your lordship will find immediately after 5 minutes. After going, after about 5 minutes of going to the bathroom, my mother came near the bathroom on the relevant day.
What is the this madam? What is it?
As far as marriage is concerned, there are enough materials. She, in her 164 also same story she had stated. The cross, it was not demolished. Mother had seen him jumping the wall of the washroom towards the lavatory. So as far as merit, there are. But as far as age is concerned, of course, the requirement is that the prosecution has to prove the age beyond reasonable doubt. Radiological and
Age with regard to POXO.
POXO, beyond reasonable doubt. But, ossification and radiological are two different things. And here, if your lordship finds that age is little, it's not determined as per law, lordship can call for a report, let an inquiry be done by the district
No,
judge.
age, with regard to age, that issue can always be taken care of by way of an ossification test.
No, it's a radiological. No documents, nothing was produced, only the
No, I
doctor.
mean, there can be a ossification test done now also.
Oh, yes. And lordship knows age to be under the POXO Act, the age has to be determined as per the Juvenile Justice Act, 94,
Correct, 90.
section 94. So let the session judge conduct an inquiry? If at all they can get some documents, well.
That is
well and
with
good.
regard to, that would be with regard to only if we find her guilty, him guilty. And then it'll have to be maybe converted to 370.
Ah. The
So
POCSO
in
will
I,
not be there. it will
POCSO will
go.
not be there, but 376
Ah,
will be there.
that will be there.
376 will be.
But if POCSO goes,
If-
presumption will go. If POCSO goes, presumption will go. And
129
from the
section will go.
medical report, your lordship has already seen. And page 16, your lordship will find that victim admitted that within 5 minutes her mother came. And which is apparently from the medical report that no such incident occurred. So if that also goes, then I get the benefit. And in that case, I am entitled for bail.
My humble opinion, Lordship can call for a report of the victims.
In every case, lordship, they cannot say that this court will call for report. They have to prove their own case beyond reasonable doubt. They got their opportunity. Now I am behind the bar for 18 months, lordship.
No, but what is your case? Is there any enmity between you and the family of the girl?
Yes, there is lordship, it is there.
What?
The enmity is there.
What is the enmity?
In cross it is suggested, but
What?
that was denied. But ultimately they have. to
What was
prove
the,
their
what are
own
the
case.
suggestion?
That's what I'm speaking of. In page 13, it is not a fact that I am deposing falsely today that on the relevant day at about 11:30 AM, when my victim daughter went to bathroom and when she was about to lock the door of the bathroom, accused forcefully entered into the bathroom and committed rape on my victim daughter forcefully. And last part of the last paragraph of page 13, lordship. It is not a fact that we demanded money from the accused at the relevant time, and as accused failed to give to our demand, we concocted a false story, and I lodged a false case against the accused.
You see, one thing is that she's a class 9 student. There are 4 tenants sharing one bathroom.
But all cases are not on the marginal, this borderline of 16 to 18 years. I'm saying only in respect of this case to get a report. He's saying that every case will get, not every case. It is
Placing one
16 to
judgment-
18 is a borderline case. That's
Just
why
I'm
I'm
placing
saying.
on judgment of our High Court lordship, where it is single judgment is held to be good law, wherein it is held that prosecution have to prove the foundational fact. Here foundational facts are that the age of the girl and whether actually rape has been committed or not. Both are against the medical report negates that. They will get their turn at the time of argument, but for that, I may not be kept in custody. That is my humble submission to your lordship. And considering the matter also, lordship has granted bail, that copy, one copy I have also given. In Mohiuddin's case, lordship has granted bail, considering the merit of the case. In paragraph 48 of Monirul Islam case, lordship, it is well done, that they have to prove the foundational fact.
Foundational facts, those are
Settle law, I'm not denying that.
that
We
is
have to.
Supreme Court decision, nothing to do with this High Court. And that is not the issue. The issue is basically just truth has to be found out. What is the truth? So that is what is required. We can allow you to go on bail, provided that in the meantime, let the authentication test be done.
To that I have no objection.
Whether you have objection or not,
No, no, from evidence.
That is lordship's,
that is our prerogative, not yours.
Oh, yes.
I'm bound by your lordship.
Only thing is that do you object to no, it's not you. That woman that lady has to be, that victim has to be examined. Now, how to do it? You would have to direct the under 391.
391. Or 154, I think. Yes. That is during the investigation.
there was no birth certificate, nothing exhibited.
No, she said that we
Good.
did not fill up the form. The mother said there was a,
She is a student, but she did not produce any document.
no,
Huh?
what she said is,
She said in PW five, page 15, your lordship will find that occupation resolution.
But
that
did
is
you
there,
take
she
the
says
stand that she was an adult? Where?
in both her cross examination as well as mothers. Page 14, your lordship will find, it is not a fact that at the relevant time my daughter was above 18 years of age. And similarly to victim lordship, it is not a fact that at the relevant time I was above 18 years of age. So the both were cross examined police.
Last time student. Last time student, 15 years old. We have to compare it. We have to relate it back to that previous member. The problem is from 18 years to this. When you compare it, this is how it is.
in the FIR as well as in the mother's statement, it is said she was 15 years at the time of occurrence. She during her deposition in 2021, she said, I am 18 years. So she was again 15 years. Otherwise, other evidence shows that she was 15 years in 2018.
Why should we disbelieve what has been recorded by them?
No, they have to prove the age, okay, as per Juvenile Justice Act, section 34 is there, okay. Juvenile Justice Act. They have to prove their age according to that. Just near take your logic.
Just show,
Section 34 2.
just show me 34.
JJ Akandi,
Not for the, sorry, protection of that.
Project Poxo Act,
Poxo Act,
Poxo.
okay.
34 isn't it?
Almost.
Ah, nice.
That here in 34, it is said that if a child, question of child is come lordship, then the session judge has to ascertain it as first 34. Procedure in case of
This is where the commission of offense is by a child.
then surplus 2 will come also. If any question arises.
So this is the accused being
Whether
the child.
person is a child or not. So here it is not that whether he is accused or victim.
No, the opening sentence is the accused.
If it is lordship there, then second column is not required. It will connect both.
We'll have to see whether
This, I think it's only the accused. Otherwise, there are judgments of Supreme Court. It has to be dealt as per 94.
oh, that is there. 94 has to be done, but
Age of the victim.
Yes, so we were just thinking aloud whether we remand the entire matter back to the learned trial court to consider the age of the victim in terms of section 94 of the JJ Act. And in terms of section 94, then the school register of the first school, all those will have to be called by the court, which it can be done by the court. And in which case, cross-examination will have to be allowed.
One thing can be done, like in case of accused persons, Lordship will direct the district, the session judge will summon. And then they will do the examination, cross-examination, and then they will send a report
Send it
within
back.
a
But
month.
that can be done also.
That can also be done,
That can also be.
like in case of accused person, Lordship does. That will expedite, I think.
I think, okay. Then, but we'll have to send back the case to court.
LCR has to be sent.
And we don't need also, we have got the paper.
Yes. It's done.
So in the meantime, we allow him to go on bail. Heard, mister?
Yeah. Yes.
Yeah, I'm with learned counsel for the applicant. Who prays that the sentence imposed upon the applicant should be suspended. Relating to the impugned judgment dated judgment and order dated 21/1/23. Filed by the learned special judge, Baksa. In special bracket POXO case number 114/2018. By which the applicant appellant has been convicted under section 4 of the POXO Act and sentenced to undergo rigorous imprisonment for 15 years and to pay a fine of rupees 20,000, in default to undergo rigorous imprisonment for 8 months. The counsel for the applicant submits that though the applicant had questioned the age of the victim girl to the effect that she was 18 years and above on the date of the incident, the prosecution did not prove the age of the victim as being below 18 years on the date of the incident. He submits that the said requirement of proving the age of the victim as being below 18 years was a requirement of law under section 34(2) of the POXO Act 2012. He further submits that the paper book submits that the medical report of the victim girl shows that the hymen of the implies that the hymen of the victim girl was intact, and that in the opinion of the doctor there was no evidence of recent sexual intercourse. He submits that though the doctor had given an opinion that the girl was between the ages of 16 years and below 18 years, as per radiological evidence, the learned trial court was duty bound to come to a definite finding regarding the age of the victim girl. In this respect, he has relied upon the judgment of this court in the case of Manirul Islam versus the state of Assam and others, reported in
2021 3 GLD, top your lordship.
2021 3 GLT 128. That's all. Anything else?
And from cross examination, that incident took place only for 5 minutes, so there was no chance for.
First off, he also submits that in terms of next para, he also submits that in terms of the cross examination of the victim, it appears that the
Both were in the bathroom for 5 minutes.
5 minutes is enough.
No, lordship, she said, lordship, in your first, she was taken to bathroom, her mouth was gagged, so the whole.
Submits that what have I said?